Calling case number 22397751. This is Midtown Park Owner LLC versus Aisha Waters and all occupants.
Carolyn Cohen, P49391, appearing on behalf of the plaintiff.
Morning, Your Honor. Ted Phillips, P35900 for the defendant, who is present in the Zoom courtroom.
Thank you.
Splatter, say your name, please.
Aisha Waters.
Your Honor, the parties have came to agreement on this one that there'll be a conditional dismissal entered for a total owing of $5,398 through April, of which $2,400 will be paid within 14 days. And commencing in May, the rent will be paid by no later than the 5th of the month of $1,400, with an additional $400 paid by the 15th of each month. It is a 4B conditional dismissal. Is that a correct recitation, Ms. Cohen?
Yes,
So $1,400 is the monthly rent, correct?
Correct.
Okay, and you said this is 4B, $5,398, and every month my rent will be paid within 14 days. Well, $2,000 will be paid within 14 days, and then $1,400, which is the normal rent, plus $400 by the 15th.
2,400 within 14 days.
Okay, $2,400 within 14 days. All right. Okay, the court is satisfied and will enter this conditional dismissal. Let's see. Ms. Waters, does Attorney Phillips have permission to sign your name?
Yes.
All right, the court is satisfied. Thank you, counsel. We'll
and you
sign
said
this.
4B was checked, right, Mr. Phillips?
Yes, that's correct.
Thank you.
All right.
Ms. Waters, you get back to work.
Thank you.
Thank you.
You are, good luck, Ms. Waters.
Thanks.
Your Honor, the other matter was 22395701.
I get out of here, y'all.
Okay, I'll get you out of here.
Okay.
There you go. You should.
Hey, Ed, you ready? You done? You ready?
Calling case number 22395701. This is RMP Unlimited LLC versus Kizzy Jacks. I have him here.
Morning, Your Honor. Ted Phillips, P35900 for the defendant.
Good morning, Your Honor. Shakina Melbourne, P number 78958 on behalf of the plaintiffs.
Your Honor, Ms. Jacks is present in the courtroom as well. Ms. Jacks, could you unmute, please?
Yes, sir.
Just state your name, please.
Kizzy Jacks.
Your Honor, we filed a motion on this one. It was not filed until this morning, though. And counsel has indicated a need for an adjournment. We're in agreement on that. The issue is one of ownership of the property, and the motion was dealing with that with some deeds attached to it. But we would be open to an adjournment. Counsel has also raised some other issues I was not aware of, so it would be helpful to get a little time to sort those through. Whatever date works with the court is fine with us.
Okay, how much time do you need? Is this you think we need 2 weeks or like a month?
I need at least 2 weeks to file the response and get some affidavits together for the motion that was filed. So the hearing can be within a month so that if opposing counsel wants to file a reply, he has the ability to do so as well.
Month
Yeah,
sounds
you're
fine.
gonna have 21 days after that, so let's just put it out for a month to see where we're at.
Okay.
And if parties need more time to respond, I'll give it to you. But if we can get it done within a month, I know that's not really that would be less than time for a response and a reply, but it will put us close. So if you all have issues, just let me know. This is a summary proceedings court, so want to keep nature.
I would just ask that it be on a Monday or Wednesday or Thursday, or is all, Your Honor, whatever date you pick.
All right. see. How about May 10th?
That's fine. If
That's
that's
fine, Your Honor.
That work for you, Ms. Melbourne?
Yes, Your Honor.
All right, let's do May 10th at 9:01 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
All right, you all have a great day.
You too.
Thank you.
Is it
Anyone else
possible,
Go ahead.
is it possible to, if I could get some host power so I can go in a breakout room with my client?
Absolutely, absolutely.
Thanks, Judge.
Whoever else needs them, just sit tight. I'll make my way around to you.
Good morning, Your Honor.
Morning. Morning, Attorney Tuttles.
Okay.
Oh, look at this back. Look at this back. So you have something at 9:30.
Yes, I do.
Mr. Lovejoy.
Yes,
Yes, I'm available, Your Honor.
All right, and is your attorney Alan Dyer here?
I'm waiting to see him check in now. Try to contact him very fast.
All right, I call him when all parties are here. We still have some
Okay.
other case.
Okay, Your Honor.
Osmond Peterson Jr. here. Is Della Aldridge here? I see Della Aldridge
I'm here, Your Honor.
Our party's ready on East Village. Courtney Butler here. Courtney Butler.
Gunner, she's in a breakout room.
She's in the breakout room? All right. Thank you, Mr. Harka.
Yes, sir. I'm standing in for Mark Landa today. Attorney Rob Visconti is standing in for Aaron Cox. Just as some housekeeping.
Oh, thank you. That's relevant information right there. Is Brandy Bogan here? Looks like that's
He is with Attorney Santiago in a breakout room, I believe.
All right. And let's see, is Lakeisha Bryant here? Let's check these breakout rooms. All right. Do you have any dismissals, Mr. Horka?
Do you have 076 still on your docket, Your Honor, at 9:31?
I do. Earl Patterson.
Yes, that's going to be a dismissal.
Let me see if it's in the file. Calling case number 22394076. This is Paquette Square versus Earl Patterson.
Morning, Your Honor. Ted Phillips, P35900 for the defendant.
Joe Horka, P75969, and standing in for Mark Landa.
Right. And the court is in receipt of a notice of dismissal by plaintiff. This case is hereby dismissed without prejudice.
Thank you, Your Honor.
This will be entered as soon as we can enter it. There's a little backlog with the files, but as soon as we can enter it, that'll be entered. I believe it'll be in the ROA, and you all will get a copy of it soon. Also.
Thank you.
Thank you. You are welcome. You are welcome.
Hi. No, I'm coming for a rapid COVID test.
So it's actually gonna be done in your car on the other side of the building. Our rapid test also unfortunately.
Your Honor, has Attorney Dyer showed up yet? Because I'm getting ready to do an in-person exam in Redford.
This is Randy Lavasser. I'm here for Mr. Dyer.
Okay.
All right, our party's ready on Lovejoy. You all want to have a conversation?
Extremely, I mean, very brief, yes. With the council.
That's all within your control.
Okay.
I'm gonna put you all in the breakout room. I'm gonna put you all in room. I'm gonna invite you all to room 7. Good morning, Attorney Lavasser.
Good morning. If Mr. Lovejoy could join me, Joanne Lovejoy.
And then you all have breakout privileges, so yeah.
Number 7.
Number 7, it looks like both. I'll let you, Tuttles is in there as well, so I'll let you all deal with it. I think you all both have breakout privileges, so.
Yeah, I'm seeing if I do.
Let's see. I'll get you in there. I'll get you.
Thank you very much.
Hello, Your Honor. I was trying to have a quick conversation with the counselor, not Mr. Lovejoy. I didn't want him to join the breakout room with me.
Yeah, he needs to talk to Mr. Lovejoy and then talk to you. I think that's what he's trying to do. So,
okay.
Yeah. Sit tight. Mr. Visconti.
Yes, Your Honor.
Good morning.
Morning.
I believe Courtney Butler is here and she's in the breakout room, so.
We had an opportunity to speak, actually, Your Honor.
Oh, awesome. Are you ready for me to call this?
I think we're ready for you to call it. I think we're going to ask the court for a brief adjournment so that we can try to work something out in advance of the next hearing date.
Okay. All right, calling case number 2239-4343. This is Ben Little Investments versus Courtney Butler.
Morning, Your Honor. Robert Visconti, P61756 for the plaintiff.
Good morning. Ms. Butler, can you state your name for the record?
Yes, Courtney Butler.
Thank you, Ms. Butler.
You're welcome.
Counsel, is it your representation that you all are close to a solution?
I believe so, Your Honor. Ms. Butler has made several payments to my client over the last 3 weeks and has reduced the balance on her account accordingly. We are going to try to work out a payment agreement that will satisfy both parties in advance of the next hearing. We would ask that the adjournment period be kept relatively brief as the court's docket allows.
Right. I mean, can we go a week? Can we go brief as in a week?
I think 1 week would be sufficient, Your Honor.
Okay, yeah, I like a week. Let's see, 4/4/4/11. Can parties come back April 11th?
Yes.
Yes,
Right.
Your Honor.
Okay. I'll see you all back April 11th at 9:01 a.m.
Perfect. Thank you, Judge.
You are welcome. You all have a great day.
Thank you.
Have a good day.
You too.
All right, it's Lakeisha Bryant here. Lakeisha Bryant. About Delaney Foster.
Yes, I'm here.
Good morning.
Good morning.
Have you talked to Attorney Horka or anyone?
No, I have not.
All right, let's try to get this conversation going. Are you requesting legal counsel?
I actually just needed what I got what I needed in the email yesterday, so I could speak with the counsel without the legal representation.
Okay, you got advice only, in an advice only capacity?
Yes.
All right.
I'll get him in a breakout room, Judge.
Okay, all right.
Mr. Tuttles, would you like to join me in number 7?
Yes, I'm ready.
Thank you.
I think you're already invited, so let's just move you all to number 8 so you both get fresh invites.
Well, I've got my client's already in number 7, and I want him present so that we can all try to figure it out.
All right, well, as long as Mr. Tellers can get in there.
I'll see if I can move him if that's all. Well, actually, it doesn't look like I can.
It's not going, but I'll let you all out. Because I think if you hit a breakout room, Attorney Tuttles, this is gonna allow you to join room 7, because this already has you grayed out in room 7. So I think if you just hit that breakout room, it'll let you join.
I have to get the invitation. I have to get the invitation first before I could just go there.
I'm gonna move all you all to room 8.
Thank you.
Or I'm gonna invite you to room 8 and then I'm gonna move everyone to room 8. That's when they're ready to, there we go. All right. So Lakeisha Bryant is here. Morning, Miss Beck.
Good morning.
Let's see. And you're on 706.
Yes.
Okay, you scheduled for 10 a.m. So you have a little time right now.
Yeah.
But sit tight.
Okay.
Leonard Markham, good morning. Is Angle Bush here?
Your Honor, I'm representing Ms. Bush. She's not here. She's in a hospital in Georgia with her husband, and I just tried to reach her, and she's speaking to the doctors as we speak. We do need a ledger on that one, and I think we need a new date. It can be fairly short. We do need to get a ledger, which we've not gotten.
Okay.
I would also note the court ROA indicates that there was escrow to be paid, but I don't believe there was an escrow order ever entered. We do have 1 month's rent, and if we can work out arrangements, I can get that to Mr. Markham from our office.
Let's call this. I'll call this case. Calling case number 2239-6142. This is Leonard Markham versus Angle Bush and all occupants.
Morning, Honor. Ted Phillips, P35900 for the defendant.
It's Angela Bush.
Oh, she's just joined us.
Is that her? Did I just muted?
Hello, just Leonard Markham.
Thank you, Mr. Markham. Good morning.
Your Honor, in this matter. Oh, sorry. Miss Bush is in a hospital in Georgia, Atlanta, I believe, with her husband who has cancer. This did come up at the last hearing. It's been a lot longer than she thought it would be there, though. We do need a ledger from the plaintiff to see if we can come to agreement on the amount owed. There was a escrow order not entered, but ordered, so she was not able to pay it to escrow. Her sister did bring the funds to our office yesterday, so we can either put that with the court or pay directly to the plaintiff as protection, but we would ask for a further adjournment. And if Mr. Markham, if you could, we could go in a breakout room after this, we could, to get the, arrange to get the ledger, that would be good.
All right, Mr. Markham, you have any comments?
Yeah, I thought it was a ledger in the, I thought you received a ledger, Your Honor.
I do have a ledger. It's a rental ledger card for August, September, October, November, and December.
Yeah, we agreed that the balance was 5,800. He said he didn't have a ledger, but we all agreed that it was 5,800.
Your Honor, the fact that the court has a ledger that goes through December, it doesn't, well, the court knows this. That doesn't mean we have it. We don't have the file, so.
I'm gonna send you over this file.
Okay.
But I don't know if you need, I'll just send you a ledger. But it does say in my notes, 5,800 parties agreed. Emergency relief was put in November. Was denied ERAP previously. Escrow order for 700 a month. So how much time do you think is needed?
Ms. Bush, what is your situation in Atlanta? Are you likely to be back in Detroit soon?
I may have muted Ms. Bush. Ms. Bush, please take *6.
Okay, can you hear me?
I can hear you now. Good morning.
Okay, good morning. My husband had a CR436 transplant, and he had side effects to it. So right now he's fighting neurotoxicity. That's damaging the nervous system in the brain. So we were designed to be back on the 3rd, which was yesterday. But right now, I don't know. I just think maybe like 2 weeks to 3 weeks.
Right, I'd ask for a 3-week adjournment.
I'm not gonna put anything out that far. Let's get a payment to Mr. Markham in the meantime. We come back in 2 weeks. If we have to call in like we're doing today, then that's what we'll do. So I'll put it out for 2 weeks. For April 8th.
Mr. Markham, can that be mailed to your address that's on the complaint, the Stout address?
Yes, sir.
Okay.
So Mr. Markham, you should get, I think you'll receive a month's, I think, was it 700, Attorney Phillips?
Yes.
Okay, so you'll receive that 700 and we'll come back on April 18th. This is, ordinarily, we would have had a resolution today, but circumstances present themselves and we'll deal with them as such. Find good cause to adjourn this due to defendant's situation with her husband. Court wishes you well, Ms. Bush, and I'll see you back on the 18th.
What time?
What time, Your Honor?
9:01.
Mr. Markham, could you hang on a minute and go in a breakout room just briefly?
Thank you.
Judge, can I check in?
At 9 o'clock. Oh, what I'm saying.
And Attorney Phillips,
yes, Your Honor, yes.
We can get you a ledger. Let me work through the docket and just, if you can send me a reminder or note before we finish up for the day, I'll get it to you, okay?
Okay, thanks.
Your Honor, I have one question.
Go ahead.
I have April the 18th at 8:30. I have a court hearing with Judge Bruce.
Okay, what time?
8:30.
Okay. So ours at 9:01. Just
okay.
yeah. So you'll be all right. And if you have to zoom in, let me know that you're approved. We'll figure it out.
Your Honor, I
Okay.
apologize. That would be a Tuesday, right? Could we do Monday or
Is
Wednesday?
that a Tuesday? Yeah, it is a Tuesday. I apologize. Let's do the 19th. Let's do the 19th. Is Ms. Bush still on the line?
Yeah.
All right, we're gonna do April 19th instead of the 18th, okay?
Okay. Okay, great.
That sounds like it works for everybody. So,
Yes.
all right, I'll see you all back on the 19th.
Thank you, sir.
Okay, thank you.
Mr. Marco,
Can I check? Judge, can I check in?
Hold on 1 second. Calling case number 2239-6244. This is Juwan Lovejoy versus all occupants.
Good morning, Your Honor. Good morning, Your Honor. Randy Levanser, P41712, appearing on behalf of the plaintiff.
Good morning, Your Honor. May it please this honorable court, Antonio D. Tuttles, on behalf of my client, that is Lene Harris, who is physically not present in the courtroom at this time.
Your Honor, I would just like to point out that Ms. Harris is not a party to this matter, so I would question Mr. Tuttle's standing to be here today.
Yeah, yes, I do. I represent the real estate and development relating to 12647.
Your Honor, just a little background here. Mr. Tuttle's client, Ms. Harris, lost property to tax foreclosure. Ms. Harris tried to reverse that. Judge Fassard with the circuit court rejected his attempts yesterday. Ms. Harris has no ownership in the property anymore. She's not an occupant. She has no standing to participate in these proceedings.
Your Honor, so this court can be aware what counsel just stated on record is accurate. However, because this was yesterday, my office do have an intention of filing a motion for reconsideration so we could bring forth new information to the judge.
All right, did the filing occur?
No, this was yesterday. I need at least a day to get just the reconsideration filed. It will be filed today, no later than tomorrow.
But what's currently pending right now?
Nothing. But my motion is not considered pending until it's actually filed.
Right, that's what, it's nothing filed right now.
As we sit right now, you're correct, no.
So I need some good cause to adjourn this matter.
The fact that this matter was heard yesterday, the judge granted the defendant's motion for summary disposition. Is mine after I met with my client yesterday afternoon, is my intention to file a motion for reconsideration, and it would be filed, if not today, tomorrow. That's the only thing we're asking for. Just 2 days to get it in, and once it's in, then that's considered pending.
I can't grant you an adjournment when there's nothing right now to base it off of. If that motion was filed before we were in court today, I could do that. But I can't, it's gonna be unfair to plaintiff's counsel to create an adjournment when there's no good cause right now. If it was filed, I would take it out of my hands, but it's not filed.
I'll file it today, Your Honor. And so what will happen is I'll file a motion for reconsideration on the granting of the motion for summary disposition. Then I'm gonna have to turn right back around with you and file a motion for reconsideration for the adjournment.
I think you're gonna have to file. I can't. You all are novel attorneys and experienced attorneys. And I believe that you'll have to file a motion with me as well. Because
Yes.
today I have to enter a judgment. There's no grounds for an adjournment right now, counsel.
I understand, counsel. I understand, Your Honor's position.
So, there may be a need to file another motion, counsel. Mr. Lavasser, what's your stance?
Your Honor, we would move for entry of default judgment against the occupants with 10 days to vacate.
Now, are you representing okay. And why is? Okay. Is there someone currently occupying 12647 Eastern?
Yes, they are. This is a barber shop, Your Honor, and so they are barbers who've had their business there for a period of time. So I would think that what would be fair would to give them, more than 10 days. Just being fair, more than 10 days to uplift their business that they've had for years.
I am willing to grant more than 10 days considering the nature of the business. Court to enter a judgment by hearing. This isn't a default judgment. Parties have appeared. However,
Your Honor, we do believe it would be a default because Mr. Tuttles indicates he does not represent the occupants.
are you indicating that you do not represent the occupants, Mr. Tuttles?
If of that building, I will indicate that I represent them for this purpose only. Yes. For this purpose, yes.
All right. So there's a judgment by hearing. This is a termination of tenancy case, correct?
That is correct.
Termination of tenancy case with a move out date of April 24th, 2023. And that's the judgment. Parties must vacate by April 24th, 2023 for a writ may issue. Any motions need to be filed within a 10-day or 3 days for any motions, 10 days for any appeals. And that is the court. Thank you, parties.
Thank you. Thank you, Your Honor. If I could meet with Mr. Lovejoy again in the breakout room.
Thank you, Mr. Tuttle.
Thank you, Your Honor.
You're welcome.
Thank you.
Judge, Mr. Horka and I are ready on that other case whenever you're able.
Calling case number 22395546. This is Plymouth Nonprofit Housing versus Brandy Bogan. And occupants. And appearances.
Good morning, Your Honor. Robert Santiago, Michigan Legal Services, P57157, on behalf of the tenant, Ms. Brandy Bogan, who is present. Ms. Bogan, would you please state your name for the record?
Ms. Bogan, are you present in the courtroom?
I had to unmute myself. Brandy Bogan.
All right. Good morning, Ms. Bogan.
Good morning.
Judge, I'm not sure if Mr. Horka is occupied in another hearing in a different court, but I can, as an officer of the court, indicate what the agreement was based on our discussions and our proposed CD.
Okay.
At this point, the total amount of rent to remain in the property would be $39.51, and that would take it through the end of April. We are going to do a CD with a pay or vacate date of April 30th, 2023 under 4A. As part of that payment, we are going to ask that, or we are going to stipulate to release escrow from a prior case, case 21351-315 in the amount of $3,160.20. That would leave Miss Bogan with the balance of $738.80, which she again will pay on or before April 30th of this month.
All right, as for the orders, to the STIP to release escrow.
We'll file a separate order for that. I'm not sure if that's been reassigned to you or a different judge, but we will do that stipulated order in a separate document.
I'm not offering legal advice, I'm offering practical advice when it comes to, this seems pretty timely. You have to execute this in a few weeks. So it may benefit you all to come up here and send it, or, well, however the documents are getting through, I would just advise to keep a close eye on them, because that release needs to be done before the 30th. But parties, I'll leave that to the parties.
Thank you, Judge. Understood.
Consistent with these terms.
Thank you.
And Ms. Bogan, does Mr. Santiago have consent to sign your name?
Yes.
All right. All right, Mr. Santiago, thank you. I'll enter this condition of dismissal, and if Mr. Porca has any issues, we'll just recall it before the end of the day.
Sounds good. Thanks, Judge. Have a great day.
All right, you too.
Judge, can I check in?
Yes, you may. What's your name?
Oh, Cheryl Miles, case number 223-96737. Can Brandy hang up?
Yes, yeah, you're free to leave, Ms. Bogan.
Thank you. Have a good one.
You too. You're welcome.
Judge, this is Cheryl Miles. Can I check in?
I'm checking you in right now. What's your case number?
223-96737. With Attorney Phillips.
What time? 737?
737.
I don't have you on my document. What time are you scheduled? What time are you scheduled?
I don't know if I didn't know if I had to appear in court today on Zoom.
You don't.
He said, oh, I don't.
Well,
So
I don't see
go.
you. I don't know. You're not on the docket today. If Attorney Phillips told you he needs to meet with you, then you should talk. You need to talk to Attorney Phillips. But you're not on the docket for today. So I'm not telling you to leave, but you're not going to hear your case called because there is no case to be called.
Oh, okay. So I have to get in contact with him.
If that's your desire, yes. Yeah.
Okay. Thank you, Judge.
You're welcome. And good luck.
Okay.
You can sit down if you want. All right.
Okay.
Good morning.
Bye-bye.
Bye-bye.
Good morning, Your Honor.
Good morning.
I'm trying to check in to see, you sent me to a different courtroom and they told me to directed me back to you. So I'm not sure what to do right now.
All right, let's start with the case number.
Case number is 233-43710. And it has your name on it.
What's my name?
Judge Adam IBN Ramada Sabree.
710. That's my name. Good morning. I need that case number one more time. 2334.
2334 3710. Says I have a pretrial conference.
I see it's changed to Christina Kennedy, Judge. Doesn't have a court date though. It just says dismissal pleadings waiting for pickup.
Yeah, I was confused myself.
What makes two of us? What's your name?
Charles Evans.
Charles Evans.
Yes, sir.
All right, because I don't have you on my docket. The sequence of cases I have 707, 708, 709, and then it skips to 711. So your file was snatched for some reason. Has it been dismissed?
It was supposed to be dismissed, but then I got this letter. Then I got the letter that I'm reading you now for the pretrial conference like a week after that. So I originally had a court date on the 21st. Sorry.
Catch you off real quick. Is the notice to appear? Is it a notice to appear what you're looking at right now?
Yes, sir, it is.
And all right, I want you to go to the bottom of the page.
Okay.
Right before you see that important, read this carefully box. It's going to be, it says date issued. What's the date? What's the issue
March
date?
21st. March 21st, 2023.
Okay. And that dismissal pleading was put in on the 28th?
21st was awaiting dismissal to order. They're still waiting for the dismissal pleading.
All right. I think.
Look on that last file.
Okay.
I thought I saw.
Let's see.
The 7-1 series. So they may have just snuck it in there or something.
All right.
So
give us a second, Mr. Evans. Don't leave.
Okay.
I
no problem.
leave. I would. We don't have it. Wow. So, I stand corrected. All right, so the notes say dismissal without prejudice, plan to submit.
I have no idea what that means.
All right, let's do this. This case is scheduled for 10 a.m. Attorney Levine will be here at some point if he's not already, or if someone from his office shortly. So he's got a number of cases with me this morning. So when he zooms in, we'll just address this with the rest of them, okay?
Okay.
I'll just put you in. I'll pencil you in. And make sure we get your case called. I have your file though, so it wasn't on the docket, but I have your file. So just sit tight and we'll call it. But it looks like it's a dismissal, but I want you to, do you have to go to work?
No, I actually took the day off for this.
All right, well, okay, that's good. So it may be a second, but it shouldn't take too long. So just sit tight and stay patient, and I'll call you back.
Okay. May I ask a question?
Go for it.
If you do find the dismissal, can my name be taken off of this case so it doesn't actually affect anything for my future rentals?
Dismissal is a dismissal. So like I wouldn't remove your name for dismissal because the case wouldn't exist. It's like being charged with I hate to use this example, but say you're charged with because this is civil, but say you're charged with something and then dismissed, the charges will still remain, but there's no conviction. So in a civil court, you're not going to you're not going to have a judgment, and the judgment is what counts. So people can file, but there's no judgment. So it'll be a dismissal to you and to name parties, but that's all that. Yeah, unfiled a case. You see what I'm saying? But
Right.
when it comes to being effective for housing, is more so a judgment. That's the thing, because you can't stop anybody from filing on you. So that would be unfair if people disqualified you for being filed on. So a dismissal will serve as that same purpose.
Okay, I think I understand.
And then we'll go over it again when we call your case.
Thank you.
Well. All right. We have some 10 o'clocks. We are into 10 o'clock. Is anyone representing Attorney Levine? Is anyone doing Attorney Levine's cases? All right,
Sorry, I'm participating in another Zoom hearing at the same time.
Your Honor,
yes.
I had a case with Attorney Levine ending in 314. He may not be here or may not have a stand-in because we sent a conditional dismissal on.
He's got 11 cases.
Okay.
Are you so 4314 has a conditional dismissal?
Correct, Your Honor.
All right. Are you on any other matters in here today?
I am not, Your Honor.
All right. Want to wait a second and see if he's gonna come in. I prefer to have him here, but if it gets too late into the morning, I'll call it and we can put it on the record, okay?
Understood, Your Honor. Thank you.
You're welcome. I see you, Mr. McCausland, you only have Jacqueline Jackson. Is that correct?
That's correct.
And do you have is there a resolution for this matter?
As far as I know, there is not.
Jacqueline Jackson.
Yes, I'm here, Your Honor.
All right. Okay. Are you represented by counsel, Ms. Jackson?
I had a conversation with the lawyer at the last court hearing, but I'll have one at the next. I was going to ask today to have the matter adjourned so that I can have someone enter on my behalf.
I'm going to put you in the breakout room with Mr. Causland. If you all can't work it out, then I'll call the case and we'll deal with it at that point. Because this is the second hearing, and as you noted, you did speak to counsel at the last hearing, so.
And Your Honor, this is a termination action.
So Ms. Jackson, I'm going to put you all in, and then you all let me know when you're ready. I'll call a case, and if you all don't have a solution, the court will make a determination. All right. Good morning, Attorney Bajani. Is Lakeisha Bryant here? Are we ready on Lakeisha Bryant?
Ready on all my morning cases, Judge.
All right, calling case number 2239-6656, Mutual Property Management versus Lakeisha Bryant.
Good morning, Judge. Healy Bajani, P 74626, on behalf of the plaintiff.
Good morning. Lakeisha Bryant. Keisha Bryant, can you state your name for the record? Have you talked to Lakeisha Bryant, Attorney Bajani?
I have not, Judge.
Okay. I'm gonna call this in an hour. This is
It was scheduled at 9 o'clock, Your Honor. 901 to be exact.
You have a point here. Lakeisha Bryant. Is Lakeisha Bryant present? Is Attorney Halbauer present?
Wait, was he on this case?
He has an appearance on this case.
Oh, well, Judge, I don't know. I think, okay, I was confused with this case. It might have been scheduled for tomorrow. Yeah.
Yeah.
Can we move this case to tomorrow, Judge? Because my notes indicate if Bill's not here, then that means that he must have thought it was tomorrow as well. Actually, yeah, he sent me an email about this case, now that I think about it, thinking that was tomorrow. We adjourn this for tomorrow at 9:01.
22. Okay, we can do that. The court finds a good cause to adjourn this matter to April 4th, 2023 at 10:01 a.m. For to hold this file. It's in the best interest of all parties to be present. Thank you, Attorney Bijani.
Judge, just to be clear, you said April 4th. It should be April 5th. I believe. Today's the 4th.
Oh, yeah, you're right. April 5th. I'm sorry. At 9:01 a.m.
Yes, Your Honor. Thank you.
Miss Bryant isn't here. She's probably expecting to come tomorrow. So I'll see you tomorrow.
Yes, Your Honor.
Is Jessica Jackson here? I think Miss Al Jabori is here. Is Jessica Jackson here?
You got it. Okay. Yep, you can have.
Good morning, Miss Jessica Jackson. And
Good morning,
Your Honor.
parties ready on this matter?
Ma'am, I'm at court.
Yes, we are.
Ain't nobody else here.
No. What's going on?
I guess we are ready, Your Honor, on this case.
You all need to talk. You all feel free to talk. I can call it. On case number 2239-6346, Mutual Property Management versus Jessica Jackson.
Good morning, Judge. Ely Bijani, P 74626 for the plaintiff.
Good morning, Your Honor. Harold Roy, P 6005 on behalf of the defendant who is present in the courtroom.
Thank you. And Ms. Jackson, can you please state your name for the record?
Jessica Jackson.
Thank you.
Your Honor, we've submitted a conditional dismissal to the court. The terms of that conditional dismissal is the amount held in escrow is to be released to the plaintiff, and the defendant shall make payments of $810 per month for 18 months starting in April. I did notice that she posted the escrow for April on the 31st. So that amount was not included in the order to release escrow that will attach to the CD. I can submit a updated order by the end of the day today.
I've already signed the consent order and the order to release escrow. So you're saying in line 4 under it is ordered, full amount held in escrow totaling, what should it be?
It should be $1,575. I included $1,125.
And is there any objection, Ms. Bijani?
No, Judge, no objection.
1,000, give it to me one more time, counsel.
$1,575.
All right. In the interest of judicial economy and reasonableness, I'm going to amend this. The order I already have, I've scratched out 1125, I put 1575. Put my signature there. Signing this, the conditional dismissal was already signed. And as noted, we are dealing with some type of backlog with entering the cases. There's nothing that we can do other than just work faster. So this is signed. be entered, and we shouldn't have too much of a backlog. We've been addressing it, of course, addressed it, so yeah. That's been signed, it'll be entered into the computer, and you all should get a copy. If you all have any issues, any further issues, just contact the court.
Thank you, Your Honor.
Thank you, Judge.
Welcome. You all have a great day.
You as well.
Judge,
Okay. But
I had a 9:30 scheduled.
Attorney Applebaum,
I represent, I represent the defendants in this matter. It's, do you want it's Curtis Jones versus D'Angelo Burton.
okay, 652.
Yep.
All right, where's Attorney Simmons?
I'm sorry?
Okay, you're representing the defendants, correct, Mr. Applebaum?
Correct.
All right, and do you know where Curtis Jones or Mr. Simmons is?
No.
All right, so, okay.
It's 10:20. I don't know if the court wants to adjourn it and give them another opportunity, or I would ask for a dismissal without prejudice and they can refile. I don't know where they are.
Judge, if you look at, sorry, I don't mean to interrupt, but Mr. Applebaum kind of interrupted me. I have one last case scheduled at 9:31. However, regarding this matter, Ms. Simmons did chat to everybody that she's seeking an adjournment due to an emergency.
Thank you for bringing that to the court's attention. You see that in the chat, Chandrika Simmons to everyone. So let's do this. No. Calling case number 2239-2652, Curtis Jones versus D'Angelo Burton, Princess Burton, and all occupants may have appearances.
David Applebaum for defendants.
All right, the court finds good cause to adjourn this matter to April 11th, 2023 at 9:31 a.m. Plaintiff's attorney had an emergency, and there is no objection from defense counsel for an adjournment. Does April 11th work for you, Attorney Applebaum? All right.
Yes.
The only issue, Ms. Simmons going to get notice in time. Let's go out. It's not gonna work. Let's do April 18th.
Okay.
April 18th at 9:31 a.m. All right, I'll see you back April 18th. Attorney Applebaum.
Right. Thank you.
You're welcome.
Excuse me, Judge.
Hold on. Go ahead.
Okay, this is Delaney Foster. I did speak with the attorney. So I was just trying to see if we can resolve that.
Sounds like that's the goal of a lot of people today, Mr. Foster, and you're behind Mr. Bijani, so allow me to call his case, and then I'll call your case after I complete the adjourned case.
Okay, thank you.
You're welcome. Calling case number, is Sheree Spencer here? Mr. Johnny, you still have 5 minutes.
I see a Cherie. She spells
Yes,
it.
I'm here.
Is that Sheree? Are you Sheree Spencer?
Yeah.
Bingo. All right. Calling case number 2239-5315. This is Mutual Property Management versus Sheree Spencer and all occupants. May I have appearances?
Good morning, Judge. Lee Bijani, P 74626 for the plaintiff.
Spencer, can you state your name for the record?
Sheree Spencer.
All right. This case was filed in November 18th. The matter was adjourned from November, well, it was filed in November. Original court date was December 9th. This matter was adjourned from December 9th to February 24th. Then scheduled for February 3rd. To help speed things up. Defendant failed to appear. A default judgment was filed on the 6th. Default judgment was entered. Motion for reconsideration was filed and scheduled. Then it was rescheduled to today's date after granting your motion for reconsideration. So, Ms. Spencer, your what is your current situation? How much do you owe any rent?
4,911, and the reason why is because they still haven't came out and did anything they supposed to do that they were supposed to fix. And I have did the instructions by texting them, emailing them, can't get in contact with them. You really can't get in contact with anybody, first off. Let's start there. They
Now,
keep
let's start with your monthly rent. How much is your monthly rent?
$451.
All right, and when's the last time you paid rent?
I think back in November.
November.
I'm not sure where that. Pretty sure it was back in November or December.
It was October, Your Honor.
Okay, because it looks like on your filing, $3,157 was owed in November.
Mm-hmm.
All right, so October, so in November you owed $3,157. So let's just put October. All right, October 2022. All right, so you're all set.
Judge, the current balance plus late fees and today's costs equals $5,662.60. This case was adjourned from 2 weeks ago because the defendant made a promise that she would pay $3,000 before today's date. That hasn't happened.
Also made a promise too. The law didn't reach either.
We were
hold on. Ms. Spencer.
Yes.
We have rules in the courtroom. When someone's speaking, the other person has to be quiet. And then when they're done speaking, it's your turn to speak. It's like an interview. You ever watched an interview?
Yeah.
It's like an interview. So I'm going to allow Mr. Bijani to speak, and then I'm going to allow you to speak. But right now, it's Mr. Bijani's turn, and then it'll be your turn. So let's just, I'm not going to mute you. Just want you to hold off on your commentary because we have a court reporter, and the court reporter only has 2 hands and 10 fingers. If she had 4 hands and 20 fingers, maybe she could take in both, maybe not. But I need you to hold off and allow Mr. Bijani to speak, and I'll hear your side.
Okay.
All right.
Thank you, Judge. So as I was stating, this case was adjourned from 2 weeks ago, and the defendant had stated that she would make a $3,000 payment. Once she had made that payment, my clients were to come in and make the necessary repairs. No payment has been made since October of last year. There is a large balance that's due and owing. This case is fairly old, roughly 5 or 6 months, and we haven't received a payment in quite some time. And today we are seeking a judgment.
All right, and Ms. Spencer, did you place any monies in escrow?
No.
Okay. Why haven't you paid your rent?
Because You can't get in contact with anybody. You can't reach anybody. You
Oh,
don't know who you're
hold on, let's go with number one. You can't get in contact with anybody. How does getting in contact with anyone, what does that do with paying rent?
Because who am I paying the rent to? Who do I know I'm giving my money to?
That you can always escrow with the court. So if you want to escrow with the court, send it to the attorney, that's acceptable. I want to make sure I'm your issue. What's the second issue?
Okay, no problem. The second issue is we got to pay them to pay our rent. We can't do the old way. We're putting money order in the box or giving them a money order. We got to go search to a store to pay extra $62 or $32 to pay rent. Then I stopped paying rent first off because they're not fixing anything. I have leaks in my house literally right now. My ceiling is about to cave in. They're not fixing anything. They're sending random people out and constantly looking at the problem and not fixing it. And I have undone floors. I have undone counters.
They said they're sending random people out. Who are they supposed to send? What makes them random?
They're sending random maintenance people out. They have sent out 4 different people to my house.
They're sending maintenance people out. What have the maintenance people done? Have they addressed anything?
No.
So what is this coming out? You say hello?
They keep sending people out to look, just looking at the problem. They have came out one time and have done the floor. And I still have pieces on my floor from when they have done.
Are you at your house right now?
Yes.
All right, I'm going to put you in a breakout room. I'm going to recall this case. I want you to show Mr. Vijani the issues, and you all come back out of the breakout room, and I'll recall this case.
Okay.
All right, I want to make sure you all are on the same page with the issue, and I don't want to share this with YouTube and the rest of the world. So,
Yes, Judge. Judge, just a quick note. After I do meet with Ms. Sabree, I do have to go to another courtroom, but I'm going to come back as soon as I can.
Okay. All right.
Thank you.
Your Honor, I have a dismissal.
Okay. Thank you for letting me know. Room 14.
Thank you, Your Honor.
You're welcome. Calling case number strike that. Calling case number 2334375 for McCoy Townhouses versus Bakari Campbell and all occupants. May I have appearances?
Thank you, Your Honor. Jackie Snyder, Powdar, on behalf of Mark Wasbury, 82554 is my P number, and we represent McCoy Townhomes. And this is a dismissal, Your Honor.
Is it a dismissal with or without prejudice?
Without.
All right, court will enter this dismissal without prejudice. And we will process it upon receipt. You have a great day.
Thank you, you too.
All right, Attorney Wasbury, I said hello.
Will do, Your Honor.
Counsel, our party's ready on Jacqueline Jackson. Is Ms. Jackson here? I'm not sure if I recall. Okay. I think I'm.
Yes, Your Honor, I'm here. I was just in breakout room number 7 with the other attorney. And I breakout room because within the first few minutes, he told me to hold on because I informed him that it's a payment.
Calling case number 2334375 The King Real Estate Management versus Jacqueline Jackson and all occupants. May I have appearances?
John McCausland for the plaintiff.
Thank you. And Ms. Jackson?
Jacqueline Jackson.
Thank you. And our Do you reside, Ms. Jackson, on Sussex?
I do, 15343 Sussex.
Don't tell everybody your address. That's why this, but thank you.
Sorry.
Thank you, Ms. Jackson.
Sorry.
All right. Have parties been able to work out a resolution?
Your Honor, may I? He put me on hold and he put me on mute and we didn't speak at all. So I clicked back so I could hear when you called our case, and within minutes you called our case. So we actually didn't speak about anything. The first thing he asked me was, the landlord wants the property. I said, but this is a non-payment of rent. And so he said, well, let me take a look at it. And then from there I was placed on hold. So we haven't spoken at all.
It is a non-payment of rent action. At this point, the balance owing is $4,425 plus the court costs. And so we would be looking for a judgment that permits Ms. Jackson 10 days to come up with that money or to vacate.
All right, and what's the monthly rent?
The monthly rent should have been, the monthly rent, the first 24 months was $1,000. I received an email somewhere around November stating that the monthly rent would go up to $1,250. From there, and then they said they would send a new lease. I have not received a new lease. I received a non-payment of $1,500. So I was waiting to see if they would submit what is it, the ledger, and then also the lease to, because in the previous lease the late fees were astronomical. In fact, the attorney in my last case said that it was, you know, the fees were beyond, you know, what they should be legally. So I'm asking the court today to adjourn this matter so we can go to trial, so that we can look at the original conditional dismissal to have them enforce that. And then also to find out whether or not Mr. Siegler and Decama Realty is actually owed, considering the first 24 months I paid and he received my cash money as far as Sarah funds without a COC. So we are really trying to resolve this.
Actually, if I can indicate for the record, Your Honor, that there was I guess a previous action with a conditional dismissal. I'll take your word for it, but that is a separate and distinct action based on the separate and distinct notice to quit and lawsuit. This is a new notice to quit and a new lawsuit, and there would be no reason to go reopen an old conditional dismissal. With respect to the issue of whether or not we send her a new lease agreement, we're not about to send her a new lease agreement as long as she continues to be delinquent in her rent. So that's just not going to happen. She needs to bring her rent current, and then they could begin talking about a new lease.
And parties will have to agree on a conditional dismissal. That's one of the both signatures need to be on there. So we wouldn't be able to enter a conditional dismissal if we wanted to, because that's not on the table right now.
I think I may have misspoke. I didn't want to enter a conditional dismissal, but file a motion to enforce the conditional dismissal, which was the list of repairs that needed to be done by a certain date. Mr. Siegler has ran away with the Sarah funds, my first 12 months of cash money when I paid on time, and it's just time for a court to see it and finally make a judgment.
Okay. How much money did Sarah cover, and what's wrong with? All right. Okay, let's start here. 4424. Counsel, how did you come up with $4,424?
Give me a moment. Let me bring that up. Oh. $4,424 is February, March, and April rent. of $12.50 per month, plus a late charge of $225 for each month.
$225
Correct.
per month. We have $12.50, and could you, is that February, March, and April?
It's February, March, and April, correct.
All right, and when is April rent due?
April rent's due in the first month.
When is it late?
I believe it's late on the second of the month.
Are you sure? Is that what the lease says?
Well, the lease is expired.
There is no lease.
Parties. So this is what I'm gonna do. Because really, I mean, the rent will probably, since there is no lease, there are no terms. So the court finds this late charge to be a bit excessive. We want to reduce it to $100 per month.
So if I could help you with the math, Your Honor, that would reduce the claimed amount to $4,000 even.
Okay.
Is that right?
Your Honor, is there a
36,
CLC on file
35,
for this property?
37. It'd be $4,050.
$4,050. Okay. And Ms. Jackson, when can you pay this $4,050?
And vacate the property,
It's a
or just pay the 4,000 and
It's a pay or vacate.
if I can stay in the property, I can pay it within 45 days.
If you work out an agreement with your landlord, that's separate from the court. And I can't offer legal advice, but maybe if you pay them something and convince them to work out an agreement, that's one thing.
So,
But I give you 10 days to make a payment of $4,050 or a writ may issue.
Oh, Your Honor, there's also the
How is
matter
that
of
fair? How is
That's
that
the
fair when they don't have a COC?
We actually do, Your Honor.
There's a certificate of compliance in the file right here. I have it. I'm looking at it.
Okay.
1533 Sussex.
And we were in communication with the
Oh, wow.
Department of Building and Safety Engineering last week and confirmed that the certificate of compliance is still valid and in effect.
All right, and what were you saying, Ms. Jackson?
Last week, he completely rewired the furnace. They completely redid the whole door frame because we weren't able to exit the front door. And then they completely rewired the side, the electric, the outlet on the side going to the basement, which is the 4 of 5 items on the conditional dismissal. I have no problem paying the $4,000. I just don't think that it's fair that he gets to keep the entire 24-month lease, all the SARA funds, and still get time and time to put together a CLC and piece together this house. It's just not fair to me.
Were the SARA funds credited to back rent that was owed?
Absolutely. And he got everything. He didn't get a CLC until the 24-month mark of my lease.
All right, the escrow, was there a 20% escrow?
May I speak on that? It looks like he got it and he sent it to a different address under a different tenant's name. And it should have went to me.
Well, at this point,
he sent it to another address.
There is a rent escrow. And if the property were properly returned in proper form and condition, and there was no rent outstanding, I presume she would get that back.
And what does that look like?
Was there Was there an 80-20 split on the Sarah funds and that 20 wasn't credited or she didn't? I just want to make sure that that isn't an issue.
According to
As
the
far as
attorney
I
that I
know, it
spoke
wasn't
with,
an issue. And the issues today are for the rent that is due in February, March, and April of 2023. Sarah funds had to do with a period a year ago.
it really is, it was October, sir. And working with United Housing Coalition this whole way, they looked the last court date, we went into the breakout room, we looked and saw where my 20% was, and it was assigned to another house under another tenant, and he definitely got it. So that's why I came back to court today to say, can we?
Why can't UCAC, why didn't UCAC represent you?
I'm not sure. I'm not sure.
All right. The court is gonna.
But they did in the past with initially Valerie Dahlstrom and UAC with the conditional dismissal from October 2023. That was.
So you're talking about this case. This is all right. The court is gonna enter this judgment by hearing. You have a right to appeal. You have a right 3 days to file a motion, 10 days to appeal to a higher court under MCR 4.201I. In the event that you do have issues with the escrow or have some information that wasn't ready to be presented today in court, you file that motion or you call UCAC and you draft that motion and file it, and the court will hear it. The court will hear it and the court will consider everything that you presented. But right now, the court found it appropriate to reduce your late fee by $125 for 3 months, and which would total $4,050 that needs to be paid on or before April 17th.
Your Honor, can we have $160 in court costs as well?
Excuse me, it's $160 statutory court cost. So 4050 plus 160, which is 4210. Is that correct?
That's what I have.
That sounds about correct.
Okay, $4,210. So if you, as you stated, you don't have a problem paying them, Ms. Jackson, talk to your landlord. They can file for a writ of eviction on or before. I mean, if you don't redeem, they may file for a writ on April 18th. You understand?
April 18th?
I understand.
The payer vacate date is April 17th. So April 18th would be, because April 14th is a Friday. So
I think 10 days is unreasonable considering you gave him 24 months to put a house together.
Is what the court rules allow me to give you.
Okay, fair enough.
That's all. That's all. If I can give you 30 days, I will give you 30 days. And the next person I'll give the next 45. But if I run my courtroom like that, I'll be inconsistent and I'll really be unfair to everybody. So I'm encouraging you to work it out. Work it out with the landlord.
No.
And I wish you well, Ms. Jackson. But
thank you, Honor.
You understand what the terms are today. It's a hearing by judgment, a judgment by hearing, in the total amount of $4,210 to be paid by April 17th, 2023.
Okay, thank you, Your Honor.
Welcome and good luck. You all have a great day.
Thank you, Your Honor.
You're welcome. Ms. Jackson.
Excuse me, Your Honor.
Yes.
This is Della Aldridge. I don't see either counsel, my representation or the other counsel for the defendant. I don't know if we're supposed to be in court today, but we did have the court day, but we were supposed to have a conditional dismissal.
How you doing, Mr. Aldridge? Yo,
I'm good. How are you?
I'm doing well. I won't call anything like that. And the Madam Court Reporter is gonna take a break, so we'll be off the record for a second. Attorney Newman or Attorney Myers is your attorney, right?
Yes.
Okay. Have you called him?
I've called him, I've texted him and haven't heard back from him.
All right.
I did make the $1,300 payment and I also made the payment for rent for April.
All right. You have to go to work?
No, I don't have to go to work, but I was in a car accident and I'm kind of medicated, so I'm sore and just ready to lay down.
All right. I want to give them a call before I tell you to leave. So just press your device on mute. Thank you for noting this thank you for informing me, and we'll see what's going on shortly.
Okay, thank you.
You're welcome. See, Angel Williams is here, waiting patiently. Attorney, what is Swiss Tech Levine? Let's see, Brent Ingram. Attorney Ingram. Attorney Ingram. Is Vincent Wade here?
Yes, I am, Your Honor.
Have you spoke to Mr. Auxilio?
Yes, Judge. Yes, I did.
Okay, are you all ready to? Well, my court reporter is out right now, so she's taking a break. So she'll be back in 5 minutes. So I can't call your case right now. But if you all need to talk.
No, Mr. Wade and I have had a chat and we've achieved, I believe, a conditional dismissal.
Okay.
Isn't that
All
right,
right.
Mr. Wade? Did you get my proposed conditional dismissal? Yes, I did. And that's okay?
Yes. Okay. All right, well, I'll note it, and as soon as she's back, we'll call that case. I'll set it aside. You all need a break this time. Let's see who else is let's see who else is ready. So you're next up, Mr. Wade, Ms. and counsel. You are next up. All right. Is Charvetta Livingston here? Charvetta Livingston? Mr. Vijani, I see your hand is up, as well as Mr. Fawaz.
Your Honor.
Oh, Mr. Vidar, how are you?
Not too bad, Your Honor. How are you doing today?
Doing well.
And so I just wanted to update you. I'm on the Charvetta Livingston case. She indicated that she would not make it today, so I'm covering for her. She has a conflict with class.
All right. Can't be mad at education. All right. Have you had the opportunity to speak to Mr. Flesland?
I have. I believe he's waiting for a little bit of feedback from his client, but I'm prepared to move forward when he is, Your Honor.
Okay. All right. As stated, the court reporter needed a quick break, so we have a few minutes to do some housekeeping matters. Mr. Fawaz, good morning.
Morning, Judge.
Are you on the plaintiff's side?
Yes, Judge.
Okay. All righty. And is Avalon PE present? Are you ready to proceed on your matter, counsel?
Yes, Your Honor.
All right. So I'll set this aside. Right. Is to be called shortly. And Mr. John.
Yes, Judge. I'm sorry, Judge. I don't mean to rush the court, but I'm being called in like 3 other courtrooms. I just have one matter that's ready before you.
Yeah, but there won't be any court reporters, so I think you should go. Come back when you can. It's not processing right now, but.
So there's no court reporter?
No, she had to take a break.
Oh, okay.
So, I mean, she'll be back in like 5 minutes, but I don't know if it'll be 5 or 3 or 10, so.
Sure, Judge. I'll just be on standby for 10 minutes and then I would have to go somewhere else. I'll return back as soon as I can.
Hello, Attorney Newman. Is that Attorney Newman or are you a plaintiff or defendant?
Yes, good morning, Your Honor.
Good morning. What matter are you on?
I'm here on East Village LDHALP versus Della Aldridge, case number 22-392-294.
I know one matter. Is Attorney Myers present? Have you spoken to him?
We sent in a conditional dismissal. Apparently it hasn't reached your courtroom yet, but I believe I faxed it over last Friday.
It may be in the file. It may be in the file. It may even be signed. I don't see it in the file, but I know I don't have any pending documents to sign. I've been going down to myself to make sure we don't have any documents pending. It's just an issue with entering everything with one clerk. We have a ton of documents and one clerk, and I don't have a clerk code. I can't do that. So we're getting some assistance in the courtroom, and that's a side note. We can put this on the record as soon as Madam Court Reporter comes back. She had a bit of an emergency, so.
That's fine. I do see Della Aldridge is in the gallery. I don't see Mr. Myers.
And Ms. Aldridge did indicate the same thing you did. So if I would feel comfortable putting this on the record without Mr. Myers, as long as Ms. Aldridge and you saw eye to eye.
And
That's fine, Your Honor.
Just so the courts know, Attorney Myers is out of town this week, so he probably will not be here this morning.
Are you standing in for him, Mr. Featherston?
I can if need be.
All right. If there's no issue, why not? Why not? Where did he go? No, you don't have to answer. All right, so this case is full. You're number 3 in the queue, Mr. Newman.
Okay, thank you, Your Honor. I just emailed a copy of the conditional dismissal over to Mr. Featherston, so he has a copy of it.
Thank you.
We may try something new today. Get this dismissal to us real time. right, looks like we have a courtroom email set up. Not quite ready to use it. May start working with it next week, but if you all need to, yeah, we'll have a backlog by next week. If we're in a situation where documents need to be sent, I'm going to allow you all to email them. We're gonna have some rules, and you don't want emails at 3 o'clock in the morning, but I will allow counselors to email documents to the court against the suggestion of some who've tried it. I'm a firm believer in email over fax. So, and Ms. Dawson, no, I'm not filling in for Alicia Jones-Coleman. Chances are you're supposed to be in Judge JK's courtroom, which is 436. Where's Ms. Dawson? Is she here?
Yes, I'm here.
How you doing, Ms. Dawson?
I'm good. How are you?
Doing well. What's your case number?
I don't have it offhand. I really don't.
We need you to get your case number. Because most likely this is the issue. Judge Coleman was in here, then Judge JK, and then me. So this cases are in 538 right now. So you're likely supposed to be in 538, but I don't want to tell you to leave, and I can't confirm it, and you don't have a case number. Is the case under your name?
Yes.
Is that the correct spelling of your name?
Yes.
All right, I'm gonna see if my clerk can look it up to confirm.
Did she say something? I saw Dawson.
Dawson's
Dawson
like
Lee.
right next to you. Is it Attorney Newman who had a conditional dismissal that he sent over to Attorney Featherston?
Yes, I've sent that over to him.
All right, I'm gonna put an email in the chat. I'm gonna see if it works. It may not work because I don't know if I have access to the email yet, but let's give it a shot and see if these are forwarded to my email, or let's just see where this goes.
And Ms. Selena Dawson, you have signed into the wrong courtroom. If you can grab a pen and paper, I can get you to the correct judge.
I'm ready.
Okay, the Zoom number is 360-538-0000.
Thank you.
You're welcome.
All right, calling is Mr. Bajani still here? Did we weather the storm? Let's see. All right, as promised, calling case number 2239-5224. This is Southeast Michigan Property Management versus Vincent Wade Jr. and occupants Alma Ross. May I have appearances?
Judge, for the record, Scott Ausilio, P42310, appearing on behalf of the plaintiff.
Thank you, Mr. Ausilio. Mr. Wade.
Hey, how you doing, Your Honor?
Doing well. Can you state your name for the record?
Yes, Vincent Wade Jr.
Thank you, Mr. Wade Jr. Thank you for your patience. Parties worked out an agreement.
Right, Judge, a conditional dismissal.
All right, and would you like to put the terms on the record?
Yes, Judge. Defendant has until May 15th of 2023 to achieve a current status on his ledger. Right now, his rent that is due and owing is the amount of $3,680.21. And that's good through April 30th of 2023. There's court costs totaling of $240. That's filing fee, service fee, and statutory attorney's fee, for a total of $3,920.21. 4B is checked. I sent a proposed conditional dismissal to Mr. Wade. Mr. Wade, you've received that, correct?
Yes.
And is that acceptable?
Yes.
And do I have your permission to sign your name to the consent?
Yes.
All right, so Mr. Wade, Mr. Wade Jr., you, according to this agreement, the terms, I want to make sure you understand before we conclude. $3,920.21 needs to be paid on or before May 15th, 2023. Is that your understanding of the agreement?
Yes, sir.
And upon satisfaction of the judgment, this matter will be dismissed.
Okay.
But if you don't pay the $3,920.21, 4B is checked on a conditional dismissal. Look it over. Box 4B says that we don't have to come back to court for an entry of a judgment and a signing of a writ. So there won't be any notice, additional notice outside of maybe something in the mail, but the only thing that's going to trigger eviction is a breach of this conditional dismissal. Do you understand?
Yes, sir.
So if you follow the terms, this case will be dismissed after you satisfy the judgment. If not, there's a chance that a writ can issue after the 15th of May.
Okay.
The court is satisfied with both parties understanding the terms, and there is consent to sign. The court will enter this conditional dismissal, and we just ask that you all get it to us as soon as possible.
I shall do that, Judge.
All right.
Thank
And
you.
by next week, we may be able to even email in this courtroom.
That would be wonderful.
I'm looking forward to it, but I need some more. There are a few more logistics I need to work out. And I know I'm probably scaring some other people in the courthouse, so I just want to safeguard everything before I roll it out.
Good luck to you, Judge. Thank you very much.
Thank you, Your Honor.
Have a good day.
Good luck, Mr. Wade.
Thank you.
You are. All right, keeping our order. I believe you all, Mr. Fawaz, calling case number 23342-305. This is Michigan Active Buyer LLC versus Avalon PE.
Morning, Judge. East Fawaz on behalf of the plaintiff, P number 83664.
You. Avalon PE present. Anyone representing Avalon PE? Is Curtis Wright here? All right, counsel.
Your Honor, defendant was served on March 31st via personal service. We had to actually send someone out in California, so they're going to send me that POS today. I'm going to submit it to the court.
All right, if you submit it to the court with the judgment, the court will be satisfied. In the event we don't see it with the judgment, I just won't sign the judgment until I get a POS. But defendant has failed to appear. He can appear from California over Zoom. It's the benefit of Zoom. However, there is no one here. So are you requesting a default judgment, counsel?
Yes, Your Honor.
All right. Default judgment is granted. Please submit the proof of service along with judgment.
Thank you, Judge.
And hold on, one second, Mr. Fawaz. This seems like, all right, the original selling price was $25,000. Looks like $5,000 was paid toward that $25,000. Is that correct?
Correct.
So there is a redemption period of 90 days, correct?
Yes.
All right. Make sure. Yeah, make sure that's noted on the judgment. I think it's a box for it. So,
Okay. Thank you, Judge.
I'll look up for that. Proof of service, personal service.
Thank you, Judge. Have a good one.
Welcome. All right. Let's see. Calling case number 22392924, East Village LDHA versus Della Aldridge and all occupants. May I have appearances?
Good morning, Your Honor. Philip Newman, P35-499, appearing on behalf of the plaintiff.
Della Aldridge.
Good morning, Your Honor. Gerald Featherson, P83480, standing in for attorney of record Alex Myers, and Miss Aldridge is present.
All right, and Mr. Newman, we still have some technical. It doesn't look like I have access to that email yet. Thank you for your appearances. And so a conditional dismissal and good morning, Ms. Aldridge.
Good morning, Your Honor.
Are you competent to understand the terms of your conditional dismissal?
Yes.
All right. You did indicate that you are medicated right now or in the hospital?
I'm at home, but I'm medicated.
All right, as long as you can understand the terms, the court is satisfied. Mr. Featherson or Mr. Newman, you all can go ahead and enter whatever terms you want to put on the record.
I will leave it to Attorney Newman.
Thank you very much, Your Honor. The parties agree that the amount of rent owing is $4,824. Court costs are $159. Late fees are $400 for a total of $5,383. The parties have agreed that the defendant will pay $1,300 by March 24th, 2023. And I would add that Ms. Aldridge did make that payment. Ms. Aldridge is to pay $1,100 by April 30th, 2023, and $1,092 by May 15th, 2023. In addition, there is an escrow being held in a prior action, case 21-357-027 of $1,891 that is going to be released to Michigan State Holdings LLC forthwith. And I should indicate to the court that after this complaint was filed, the property was sold by East Village LDHA to Michigan State Holdings LLC. So Ms. Aldridge will be making all of her payments to Michigan State Holdings LLC.
And Mr. Newman, do you represent Michigan State Holdings LLC?
Yes, I do, Your Honor.
Okay. And in all reasonableness, we can continue this action rather than dismissing it and bringing it back with a new name with the same terms and putting her tenancy in jeopardy. So the court will accept this conditional dismissal. Ms. Aldridge, you've made your first payment. When is your next payment due?
It's due on the 30th of April, Your Honor.
And then what's the next one after that?
May the 15th.
And the 1891 is in escrow. That will be released to you. Is that correct?
It will be released to Michigan State Holdings LLC, which is the current owner of the property.
Okay, all right. All right, the court is satisfied with this conditional dismissal. Are these terms noted on the actual conditional dismissal?
Yes,
they are, Your Honor.
All right, and it's 4A or 4B checked?
4B.
All right, and we've discussed the consent to sign, but I'll say it again. Ms. Aldridge, does Mr. Featherston and actually does Mr. Newman have consent to sign your name?
Yes.
Okay. All right, the court is satisfied. Good luck, Ms. Aldridge. Recover at the I wish you a healthy recovery. And thank you, Mr. Newman, Mr. Featherston, for stepping in. You all have a great day.
You're welcome,
You too, Your Honor. Thank you.
Thank you, Your Honor. So I did send it to the email address you put in the chat. Apparently you can't get it.
I don't think I have access yet. I'll call IT and set it up. So fax it in again. So just in the event that it takes longer than usual, but if I get it and figure it out, I'll sign that one first.
I'll fax it in right now. Thank you very much, Your Honor.
You're welcome. And counsel from Lakeshore, you need breakout privileges, and Mr. Flesland, let's call you. Let's get to your case too. Our party's ready on 6766.
Yes, Your Honor.
Calling case number 22396766. This is GELA LLC versus Charvetta Livingston and occupants on Balfour.
Yes, Your Honor. Dennis Flesland, P30289 for the plaintiff.
Thank you, Your Honor. Maxfield Mudar, P86355 on behalf of the defendant, who indicated to me earlier today that she would not be present due to being tied up with class.
Your Honor, Mr. Mudar and I have been communicating back and forth. His client has proposed a payment plan in this matter that will include the current rent payment paid on the 1st of the month and a $500 payment on the 15th toward the arrearage. Mr. Mudar, as I understand it, Mr. Mudar just needs to get a confirmation or agreement from his client regarding what the arrearage is. We show it being $7,750 plus 185 court costs for a total of $7,935. But he needs confirmation, so we're asking for a control date, I think.
And that is completely.
Is that including April rent?
That includes April rent, yes, but not April late fee.
Gotcha.
And that is completely correct, Your Honor. The last thing that needs to be done here is I simply need to discuss the ledger with my client just to verify the numbers, but we've already got the payment plan proposed and I believe accepted. We're just squaring away the numbers, Your Honor.
That's correct.
Is a Monday and Wednesday better, or is a Wednesday is best for you? I know you're UCHC, so.
So due to being UCHC, my scheduled court days are usually Monday, Wednesday, or Thursday, but it's in a separate court, Your Honor. So a Tuesday or a Friday in your courtroom would actually be ideal so that it doesn't fall in line with that issue.
All right. Okay. So let's do April 11th. Does that work, both parties?
Good me.
Works for me, Your Honor.
Thank you, Judge.
I'll see you all back at 9:01 on April 11th.
Thank you, Your Honor. Thank you, Attorney Flesland.
Thank you, Mr. Mudar. Or maybe you won't see us at all, Judge.
Maybe.
Okay, thanks a lot.
Well. Mr. Bajani, are you ready on Sharice Spencer? Are you in another courtroom?
Yes, Judge.
Calling case number 25315, mutual property management versus Sharice Spencer and all occupants.
Good morning, Judge. Ely Bajani, P 74626 for the plaintiff.
Ms. Spencer, can you state your name for the record?
Sharice Spencer.
Thank you.
Your Honor, I had the opportunity to speak with Ms. Spencer, and you put us in a breakout room. She did show me the repairs that were needed, and these are very minor repairs, and none of them render the property uninhabitable. There's a small hole in the ceiling that can easily be patched up, and she claims that there was a leak. However, although it's raining right now, I didn't witness any leaks. So we're still seeking a judgment for the full amount, and inclusive of costs is $5,666.60.
566.60, correct? All right. Ms. Spencer, anything else you want to say? Is there anything else you want to add?
I want to know who can I talk to legally about these issues and this problem? Because this the same thing. I'm not, even if I pay my rent, I'm still have the same thing going on. I can't get in contact with nobody at the court or nobody to get in contact. That's the reason of me not paying my rent. So that's how I got their attention to come to court. So I need to know who can I talk to legally to get this stuff fixed. And my thing, this been going on for 2 years. I'm already a disabled person. Just got off wheelchair onto a walker. I can't have this stuff in my house. In a minute, they're gonna have a lawsuit. And I also have a kid in my house. I have holes in my floors. I have nails on my floors. I have leaks going in panels and everywhere. They're not sending nobody out to fix anything or do anything. So legally, I need some help at this point.
Well, you notified that people. How much time? Well, let's see. Court is authorized to give 10 days, and I'm following the court rules. Court will enter a judgment by hearing in the amount of $5,662. You know what? The court's going to abate the repairs. Court's going to abate the rent and enter a judgment for $5,162.60. That's a $500 credit, so that the hole in the ceiling and the leaks could be addressed. In the event that it's enough to get it fixed, that's great. In the event that it's not, at least you were able to get some assistance on that. So the court is entering a judgment by hearing in the amount of $5,162.60 to be paid on or before April 17th, 2023. If you are able to work something out on the side, make sure you get it in writing, Ms. Spencer, because oral agreements are harder to enforce, I said. So get it in writing. $5,162 needs to be paid by April 17, 2023, unless there's some issue or there's some agreement outside of court that parties have entered into.
Thank you, Your Honor.
You're welcome. And Ms. Spencer, there are attorneys here from Lakeshore Legal Aid. If you would have a desire to talk to them, I will put your hand up in the chat, and they can have a conversation with you. Maybe they can assist you with something.
Okay.
You have a great day, and I wish you luck.
You too.
Sheree, in just a second, you'll see a prompt on your screen to go to a breakout room to speak to an attorney with Lakeshore Legal Aid.
Okay.
Hello. Oops. Hi,
Yes,
Judge.
sir.
This is,
Yeah, Mr. Paul, okay, are you all ready?
Yes, I have a resolution with Mr. Foster, Your Honor.
All right, great. Calling case number 22394064. This is VELT Investments versus Delaney Foster.
Good morning, Joe Horka, P75969 on behalf of the plaintiff.
Thank you. Mr. Foster, can you state your name for the record?
Delaney Foster.
All right.
Your Honor, this is a non-payment of rent case. The rent to retain is $7,664. Court costs of $160. Total of $7,824. Mr. Foster believes Sarah will be sending a payment to Mr. Landau's client for $2,400. Between he and Sarah, the balance must be paid in full on or before April the 30th.
Is that your understanding of the terms, Mr. Foster?
Yes. Yes, I received the email from Sarah yesterday, so I'm not sure when do they send payment to the landlord, but I did receive confirmation email yesterday, so yes.
All right, so 7664 plus 160 brings you to 7824. Says Sarah's going to knock out 2,400, which is a good push for you. And you'll handle the rest of the balance by April 30th.
Correct.
All right. And is this a consent judgment?
Gonna do either a judgment by hearing as to all occupants, or it can be a consent judgment, Your Honor. I was just trying to take his name off if possible.
Okay, if there's a request to, okay, yeah, as long as both parties agree to a removal of all occupants, the court is willing to do it and enter a judgment by hearing. This may assist you in the future. So I have both parties consent to enter that judgment for all occupants. So we'll enter a judgment by hearing in the amount of $7,824 to be paid by April 30th, 2023. Good luck, Mr. Foster.
Thank you.
You are welcome. Thank you, Mr. Harkin.
Thank you.
You are welcome.
Am I okay to leave?
You are okay to leave. Have a great day.
You too.
All right.
Your Honor.
Yes, sir.
I'm still here for my 10 o'clock case with the conditional dismissal.
Okay. Let's see. Okay, this is Latoya Murphy.
Yes, Your Honor.
Calling case number 22394314. This is Bill Properties LLC versus Latoya Murphy.
Gerald Featherson, P83480 on behalf of Ms. Murphy, who is present.
Ron Tingham on
Latoya
behalf of the
Murphy.
plaintiff, P80491.
Latoya Murphy.
Thank you. And the court is in receipt of a conditional dismissal and will sign it on the bench and get it out to all parties. The terms of the conditional dismissal are as follows. There's $740.40 in rent due and owing. $150 in court costs, other monies due of $300 for a total of $1,190.40. The defendant shall pay that total in 2D in increments of $100 until the balance is resolved. First payment is to be paid April 2023. Last payment, March 2024. Defendant defaults on any payment, plaintiff may reinstate the case pursuant to 4B below. This is a 4B action. We would not need to come back to court for this matter. Do any of the amounts need to be updated?
Not as far as I know, Your Honor.
Is that an accurate understanding of this?
That's correct, Your Honor.
All right, well, the court will sign it and we will enter it. Please allow for a few days. We do have a significant backlog, but we do have as many hands as possible working to get this stuff processed. So I appreciate you sending this in ahead of time. That surely helps, and that concludes this matter.
Thank you, Judge.
Your Honor.
Attorney Levine, I believe we have a few more cases, and they're eligible for default in the event that parties are not here. Well, Attorney Ingram, excuse me.
I'm sorry, I have a question. I'm with Bill's property as well, and he just left out, and we had a reappearance from March 21st to come back today at 10 o'clock, and he didn't mention anything about my case.
All right, well, the he that you're referring to was the defense counsel. The attorney for Bill Properties is here, and if you would like to speak to him, I can put you in a breakout room. How does that sound?
I have no objection to that, Your Honor.
I have no different. We can do that.
I would like to do that as well with him. This is Jakaya Leonard Felton.
All right, we're court's gonna call a timeout. All right, so Attorney Levine is Mr. Ingram. Attorney Ingram is standing in for Attorney Levine.
That's correct, Your Honor.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 defendants. So, not saying that all of you all can't talk to them, but Ms. Pearson, you're first. All right. Ms. Beck, Ms. Bridget, go ahead. Go ahead.
Apologize, Your Honor. Nicole Van Blarken with Lakeshore Legal Aid. I could speak with some of the defendants as well. And see
All right. Ms. Pearson, are you requesting legal counsel?
No, because I paid off the balance, but I do want to add where they're getting their numbers from. For one, I did pay off the $3,000.
Do you want legal counsel? You said no?
No. I just wanted to speak with the
We're gonna put you. I'm gonna put you and her. Sit tight, Attorney Laricum.
Okay.
I'm gonna put Attorney Ingram and Ms. Pearson in the breakout room so we can get that brewing while we get some of these other cases. No problem. You all are invited to room 3. All right.
Excuse me, Your Honor.
Hold on 1 second. Bridget Beck. How you doing? You're muted right now, but do you want to speak to legal counsel? Yes, you do. All right. So I'm going to put. All right. Lucky room number 7. You'll get an invite, Miss Beck, to room number 7.
Okay.
There's people there, and they'll speak to you. Let me know when you all are ready to go. All right. Miss Leonard Felton, good morning.
Good morning, Judge. How are you?
I'm doing well. Handling the docket today. I think we have a good flow going today.
I think so.
Are you requesting legal counsel?
No, I'm not.
All right, so you'll be on deck to speak to Mr. Put your hand up in the chat. I mean, not in the chat, yeah, well, in the Zoom room.
No problem.
All right, so when he comes out, I'll probably call their case and then he'll go in the room with you. And
Sounds
we'll
good.
just switch it out like that. iPhone, talk,
Yes,
please.
sir.
Good morning. What is your name?
My name is Charles Evans. I already checked in with you at 10, and you told me to wait. So
All right. Charles Evans. What's your case number, Mr. Evans?
233-43710.
Oh, all right.
Right.
Thank you. Thank you for that reminder.
No problem.
All right, don't fall asleep on me. All right, so do you need legal counsel, Mr. Evans?
Like I said, no, the case has been already done. I don't even know why I'm actually here. So that's what I was trying to wait to find out.
Make sure your case is actually done.
Could you say that again?
To make sure your case is actually done and to make sure you don't get a default judgment by accident. Yeah, that's why you're here. You know why you're here.
Yes.
You're just annoyed because it's taking a long time, and that's all right. But we'll get it processed at some point.
No
All
problem.
right, and I'll put you you're first actually, because you have checked in first. We have 710 718-709. All right. Who else? Let's see. So I have you all ready to go. 718 ready as well. All right, Mr. Ajane Johnson.
Present.
Like we've had 30 times. Have you talked to Mr. Horton?
I'm sorry. Can you say that one more time?
Your Honor, we just spoke.
Okay, you ready on your matter?
Yes.
All right. Calling case number 2239-5550. This is Plymouth Nonprofit Housing Corporation versus Ajane Hunter Johnson and all occupants.
Present.
Good morning, Joe Horka, P75969 for the plaintiff.
Thank you. Mr. Johnson, can you state your full name, please?
Ajane Hunter Johnson.
And this is a non-payment rent case, possession only. The rent to retain is $9,916. There's $160 in court costs, total of $10,076. We'd like to enter a judgment by way of hearing against all occupants only with an April 30th pay date. Either he can move, pay the full amount, or try and negotiate a written payment plan by that date.
And could you give me that move out date again?
April 30th.
23. Do you understand is this a consent? Are you all agreeing to this? Are you agreeing to this, Mr. Johnson?
Yes.
All right. Well, I'm going to enter this judgment by hearing. Mr. Horka consented to allowing an all occupants judgment to be entered. There's no objection to dismissing you as a named party and entering an all occupants judgment. That's giving you an opportunity to possibly find some more housing. This is a termination of tenancy case. Well, has it been converted to a termination?
No, we're gonna have that redemption amount of the 10,076. He's ultimately gonna try and set up a payment plan. I just don't know if my client is going to agree. So if they don't agree, he understands he's got to pay the amount removed by the 30th.
Okay, the magic number is $10,076.
Yes.
Mr. Johnson.
Yes,
And-
so I'm sorry, go ahead.
Go ahead.
So I was just because I was already in a payment arrangement with my property. And I had last time I was in here, I spoke to you and I told you that I paid the $2,500 by check. When I left out of here, that the next day I went to go ask about the balance because obviously that had been news to me. So when I went down there, they had told me that the check that I had gave them, they had been down there since I gave it to them and they never deposited because they said that they never knew who it belonged to, but I gave it to her directly in her hand and said, hey, this is here. I'm using this to go towards my balance and this is for up until my the end of January's rent, whatever. So the only rent that I was supposed to pay was from February and March, which is when I did do my last payment, whatever. And I'm also supposed to be giving her another payment today. But because of that, it definitely puts me in a different position of trying to, do a different payment arrangement because now I owe a lot more than I was anticipating because she said they never even knew that it was my check that I gave to her. But they did.
How much are your late fees?
My late fees are, I think, 100.
All right. And it wasn't drawn from your account. That check wasn't drawn from your account, was it?
No, it wasn't. So
I
didn't. I'm sorry.
All right, this is what the court is gonna do. You're at 10,000. Court's going to abate your amount by was it $100? Because that was added due to the property management group not cashing your check.
Yes.
Okay, but we're gonna go $9,976 will be the amount to be paid by April 30th, 2023. All right.
Okay, so I don't know if they're gonna allow me to do another payment arrangement because now they're like now I owe way more than what I owe before I even thought that I was gonna give them that 2,500. So I might not even do another payment arrangement and I might just have to leave before that the move out date because that's actually dealing with a lot more than I anticipated and I'm already in a payment arrangement that I'm paying more than I can handle.
If you're in a payment arrangement, are you saying was something else separate from this?
Yeah, so you said that I would have to do like if I didn't leave the property, I would have to do another payment arrangement with my.
So let me tell you what you do. In order to remain in this property, you have to pay $9,976, or if you choose to vacate, you can vacate before the end of April and no writ will issue. Additionally, all occupants is with the judgment is being entered because plaintiff has requested from the court. He said, enter this into all occupants and dismiss the named party. So Mr. Johnson, you filed a motion, we've gotten back in here. So if you were to vacate, this judgment wouldn't be in your name. However, if you want to stay, it's gonna cost you $9,976. If that's paid, or if there's a payment agreement with that amount set aside, then no writ will be filed while that payment agreement is maintained and honored. So you have some options. This is the final order of the court. And good luck. But do you know, like whatever your payment arrangement is, you need to get a new one because the payment amounts is updated. So to speak to your property management company, I can't guarantee anything, but this is what a writ may issue if $9,976 isn't paid by April 30th, 2023. And it's dismissal to you as a named defendant, and we're entering this judgment as all occupants.
Okay. So just Just really quick. Just so if I do leave before the move out date, before April 30th, I won't have to eviction won't be on my record, will it?
Be entered as all occupants.
I'm sorry, say that one more time.
No, a judgment will be entered as all occupants and won't be entered as Ajane Johnson Jr. Okay?
Okay.
You understand? You understand? Does that bring some clarity to your question?
Yes.
Okay. Well, good luck, Mr. Johnson.
All right, thank you.
You're welcome. All right, Mr. Ingram, let's get your first case called.
Thank you, Judge.
Hold on, I'm sorry. All right, we have calling case number 2334-3710. This is Bill Properties versus Charles Evans and occupants on Pilgrim.
Let me go ahead and send these screenshots over.
Brent Ingram on behalf of the plaintiff, P80491.
Thank you. Mr. Evans,
I'm here.
can you state your name for the record?
Charles Evans.
All right, Mr. Evans. Counsel, has this matter been dismissed without prejudice?
I'm sorry, Your Honor.
Has this matter been dismissed without prejudice?
Yes, Your Honor, we'll be moving to dismiss this matter.
All right, dismissal granted.
Thank you, Judge.
You're welcome. On case number 2334-3709. This is Bill Properties versus Jakai Leonard Felton.
Brent Ingram on behalf of the plaintiff.
I'm Jakaya Leonard.
Thank you. Have parties reached a resolution?
Well, we didn't get a chance to speak, but it's my understanding that I will be paying the extra $100 a month towards the balance until the balance is paid.
All right, and that, is this in the form of a conditional dismissal?
Yes.
That's correct, Your Honor.
Okay, what's your monthly rent?
$750.
And what's the total amount owed?
The rent to retain in this matter, Your Honor, is $2,250. Court cost is $160.75. So the total owed today is $2410.75.
I am asking to waive court costs.
On what ground?
COVID.
Over what?
COVID and the fact that I cannot afford it, Judge.
Counsel, are you willing to waive court costs?
I don't have authority to do that today, Your Honor.
Okay. All right. Let's see.
I've already started making payments too, by the way, Judge.
Okay, that's good. That is good. Is there, I don't have authority to waive. I mean, I do, but I would prefer to have a justification and good cause to waive the court cost, counsel. Ms. Felton. So do parties agree on the 2410? Well, on the 2250 plus the court cost? Is that an accurate amount?
Agree today, Judge.
Correct, Your Honor.
Okay, all right. How much time? All right, is this going to be, counsel, is this going to be presented as a conditional dismissal or as a consent judgment?
Conditional dismissal, Your Honor.
Okay, is 4A or 4B checked?
4B, Your Honor. Ms. Felton, do I have your permission to sign and present that to the court?
You have my permission, counsel.
Understood.
All right, the court will enter this conditional dismissal consistent with the terms on the face of the dismissal. Good luck, Ms. Leonard Felton.
Thank you, Judge.
Thank you, Judge.
Welcome. Welcome. Doesn't hurt to try. Calling case number 23343718. This is Bill Properties LLC versus Juanisha Pearson and occupants on Bedford.
Brent Ingram, on behalf of the plaintiff.
Thank you. Ms. Pearson,
Yes.
can you state your full name?
Dwanisha.
Thank you,
Pearson.
Ms. Thank you. Party's been able to work out an agreement.
We did have a chance to talk, Your Honor. It appears that there is some dispute over the amount owed. Ms. Pearson is saying that she did make a payment yesterday, which I do not have a record of. So at this point, I would request just a brief adjournment in order for me to, verify with my client that everything is paid up. And at that point, hopefully we can just dismiss this.
Okay, and would that payment have satisfied the outstanding balance?
That's what she's saying, Your Honor. But again, unfortunately, I can't verify it right now because the numbers that I got were after the fact.
He's not the original attorney that was on the case, so I do understand his behalf. When we came in on the 21st, there was a whole complete different judge and attorney for Bill's property doing the presentment. But yes, I made a payment on February 10th of $820, another payment on the 27th of $800, a payment on the 11th of March of $925, and yesterday I made a payment of $1,503. So it will completely clear out the $3,000 request. I do have to send him over the transactions that is on the app for the company, showing for one, my rent is only $675 a month. With the legal fees and including the late fees, Your Honor, and the remaining balance of the $67.50 that was owed for the month of October, where it states on the paperwork, that's what I'm paid up to. I only had a total of $2,147.50, and that included the payment after February 10th. So I was still kind of confused on where did they get their numbers from.
That's correct in the sense, Your Honor, that we do have some sort of a dispute over the math. I did provide the tenant with my email. That's another thing that I would like to discuss with her in the interim between an adjournment, and hopefully we can resolve it.
Okay, it seems like Ms. Pearson is on top of things, and counsel, I know you have to check with Attorney Levine and make sure that these numbers do add up. So how much time do we need?
A week would be sufficient, Your Honor, whatever the court can afford in terms of its calendar.
Okay, Ms. Pearson, let's see. Let's do, is April 11th fully loaded?
April 11th, Judge. It is, let's see. Oh.
April 11th. And is there a preference on time?
10 o'clock, Your Honor.
All right, it's going to be slotted as 10:01, so I know it's an adjournment, but if you come at 10, I might be able to hear it at 10.
Very good. Thank you, Judge.
You're welcome. Good luck. Good luck, Ms. Pearson. Just let's come back in a week to finalize everything, okay?
I appreciate it. Thank you.
You're welcome. We appreciate you. Take care.
You too.
All right, you're free to leave. All right. See who else we have here present. Looks like a Kamaya Goodson and Angel Williams. Patiently waiting. All right, so. And Cheryl Gray.
Yeah.
Kim Yada, I'm sorry.
How do I make this bigger?
All right.
Yes, Kenyatta's here, Your Honor. She was here. She was here.
Kim Yada Goodson is here. Is Donald Gaddy here? All right, Ms. Goodson, are we ready to call your case?
Yes.
All right. Counsel, are you ready for Ms. Goodson?
We are ready, Your Honor.
Calling case number 2334707.
Grant Ingram on behalf of the plaintiff.
Ms. Goodson, can you state your name for the record?
Kenyatta Goodson.
Thank you, Ms. Goodson. All right, we are here today for a second hearing for non-payment of rent. What is the current total amount owed?
Right now, the rent to retain, Your Honor, is $4,445. I have court costs of $160.75 for a total redemptive amount of $4,605.75.
Right, thank you. Have parties worked out some type of payment plan or agreement, or?
No, Your Honor, at this point, we're asking for a judgment, and the writ would be in the standard 10 days, so the defendant would have until the 14th to pay it.
Your Honor. Your Honor, it's Cheryl Grant. I'm the case manager for Ms. Goodson.
All right, thank you, Ms. Hello, Ms. Grant.
Hi.
Ms. Grant,
Yes.
Grant, can you put your right hand up?
All right.
Do you swear to tell the truth and nothing but the truth?
Absolutely.
All right, court is satisfied with that oath. Go ahead, proceed.
All right. Ms. Goodson has Section 8. Under the former landlord, a lease was signed. A new owner took over the building. We submitted the documentations to RPI so that they could start paying the new landlord. The new landlord refused to complete the paperwork. Once they refused to complete the paperwork, Ms. Goodson was instructed that she had to move. A letter sent on 12/28. When we contacted the landlord, talked with my manager, and she said, we're not paying the rent because you didn't complete the required paperwork. He indicated that Ms. Goodson had not signed the documentation. However, we have a copy of signed documentation, which the manager sent back to him, at which point in time he said, oh, well, too late. So I don't know, why they feel that I instructed her to move her belongings, which she did, turn in her keys, which she did. So I'm not really sure why she's being held accountable when it's the landlord who didn't complete their process.
May I ask a question of the tenant or Ms. Grant, Your Honor?
Sure.
Are you saying, Ms. Goodson or Ms. Grant, that you vacated the premises? Because that's not my understanding.
Yes, she did. As a matter of fact, I've rehoused her in a new unit.
And she did turn in the keys?
far as I know, she did.
Ms. Goodson, did you turn in the keys?
Yes.
Who did
Because
you
this is,
turn them in?
Hello?
Yes.
Yes.
Who did you turn the keys into, Ms. Goodson?
The property manager, Bill Property.
Counsel?
that's not my understanding, Your Honor. So in light of what's been of the testimony today, I would ask for a brief adjournment in order that I can confirm that. And if indeed she did turn in the keys, since this is a possession-only case, we will happily dismiss it. But again, that's something that I'll have to confirm since my property manager is not here today.
Okay. Ms. Goodson, are you working or is there?
Yes, I'm working.
Can we come back in a week or what time, when do you want to come back to court?
A week should be sufficient for us, Your Honor, because frankly, I should be able to resolve this with a phone call after the hearing.
You think you can, you think you'll be able to verify it today? Think it's possible?
I certainly will reach out, Your Honor. I don't know if I'll be able to get a hold of them today, but I can certainly try. And again, if I am able to verify that we have possession, then we'll file a dismissal.
Okay, let's come back on the 11th. This is fairly, this is a very short, very brief issue. I took notes. Okay, let's just come back on the 11th. Zoom in, Ms. Goodson on the 11th, same time, 10 o'clock.
Same phone number, Your Honor?
Yes, same. The Zoom code is 360-436-0000. It should be the same as before.
All right, thank you.
Thank you, Judge.
You're welcome. Thank you, Counsel. Thank you, Ms. Grant,
You're
for
welcome.
being here.
All right.
I was helpful and.
Okay, thank you.
You're
All
welcome.
Bye.
All right, Angel Williams and Bridget Beck. Angel Williams,
Yes.
you are with Attorney Levine, and Bridget Beck, you are as well. Has Lakeshore Legal talked to you, Ms.
Yes,
Beck?
sir. Yes, sir.
You need to speak to Mr. Ingram.
Your Honor, may I speak with Mr. Ingram?
Yeah. Yes, you may.
Thank you, Judge.
You're welcome. Let's do room number 6. I'll move you over to room 6, Counselor. And let's see.
Thank you, Your Honor.
3, let's get you to room 6.
Got
All
it. Thank you.
Thank you.
Welcome. And Angel Williams, did you request legal counsel?
Angel Williams speaking. Hi, Your Honor.
Hello. Did you request legal counsel?
Yes, I already spoke to somebody though.
Okay. And are you ready to proceed?
Yes, Your Honor.
Okay. I'll call your case shortly, okay?
Okay, thank you.
All right. There's one attorney who's processing all these cases. So we have to go one by one. And if counsel is present, they have to talk to counsel. So I think he's talking to Ms. Beck's counsel right now. We'll do that one, and then we'll do yours, and then we'll call these default judgments. So that's the flow of the court today. And I appreciate your patience. Right, that's 706. Williams 720. All right, our party's ready.
I believe we're ready to go, Your Honor.
Okay, great. Because I do have a 1:30 docket and I have to afford my staff an hour lunch, which means 12:30 is our cutoff point. And I don't want to make anyone come back in the afternoon. They don't have to. So
Understood, Judge.
yeah. It's 23343706 LT Bill Properties versus Bridget Beck.
Brent Ingram on behalf of the plaintiff.
Thank you. Counsel.
Oh, sorry, Your Honor. Nicole Van Blarkum, case 6616 with Lakeshore Legal Aid. I'm not representing the defendant yet, but I did speak with her in the breakout room.
Okay. And Ms. Beck, can you state your name?
Bridget Beck.
All right. Let's see. We're here for a non-payment of rent case. This is the second hearing. This matter was filed February, end of February. How much rent is owed, due and owing right now?
Right now, we're showing rent to retain of $7,950 along with court costs of $160.75. So the total redemptive amount would be $8,110.75. However, they are disputing that. They're saying that there's some CR payments that were made. Additionally, there are allegedly some habitability issues that we're going to need to investigate. So given those two factors, we would request at least a 2-week adjournment so that we can investigate the habitability issues as well as look into whether or not, the Sierra payments are being applied. Ms. Blaricum has agreed to forward that information to my office so that we can review it.
All right. Court finds good cause to adjourn this matter to April 18th.
Will that be, is it at 10 o'clock as well, Your Honor?
Yeah, we can do 10 o'clock.
Thank you, Judge.
Make enter this 10:01 in the system. Your notice may say 10:01. That's for me to keep track.
Understood.
And, all right. Okay, I'll see you all back. Oh, good luck, Ms. Beck.
Thank you.
Thank you, Your Honor.
You're welcome. Don't waste any time in the meantime. Do what you can do. Clarify this discrepancy. All right, Angel Williams. Let's call your case.
So I'm done, Your Honor?
You're done. You're free. I'll see you back in 2 weeks.
Okay.
You should get a notice in the mail, but it'll be for it's the 18th, correct? Did we put it for the 18th?
Yes.
Okay. All right.
Okay.
All right. Good luck. Take care of yourself.
All right.
Calling case number 23343720. This is Bill Properties versus Angel Williams.
For the record, Brent Ingram on behalf of the plaintiff.
Thank you. Angel Williams?
Angel Williams speaking. I'm sorry.
That's all right. Have parties worked out some type of arrangement or agreement?
Not at this time, Your Honor. We are asking for judgment. The rent to retain, and this is $2,275. I have court costs of $160.75. So the total that Ms. Williams would need to pay to be current would be $2,435.75.
And Ms. Williams, what's your monthly rent?
It's 7:50, but it had went up because it was 7:30 actually. It was with mutual property management. But what I'm trying to do, I still want to remain at the property. I wanted to pay 1,500 on the 6th and the 7th. Well, not well. I get bi-weekly checks. The combined total will be 1,500, and that would be on the 6th and the 7th. And then on the 20th, I will have a remaining balance of 960.75 cents. I don't know what the court cost is, but I'm just telling you my rough draft, what I had made, which is $960 will be paid on the 20th and the 21st of both of my biweekly checks. That would come up to that total. I do know that I owe a balance of 2,000 and something. I had problems of my vehicle to get back and forth to work. And it was not that I was not trying to pay my rent or anything. I need my vehicle for transportation, so I had to get my vehicle fixed a couple of times. That put me behind. And I did speak with my property management, but I haven't heard anything back. It's due. I had emails talking to him, and he knew the financial problems that I had, and I told him that I will be making payments. But I also would want, if I can, my rent date needs to be changed because my bi-weekly pay doesn't always fall on the 1st.
Your Honor, I don't have an issue since it sounds like she's not disputing the amount owed, doing a consent judgment where we put the writ out to the 22nd, if that's how much time she needs to pay the rest of it. And then hopefully it can be resolved. But as far as changing the day that her rent is due, I don't have authority to do that today. That's something she would have to take up with the property manager after today.
Okay, so the court and Ms. Williams, you did a good job. You did a good job advocating for yourself.
Thank you.
Let's see. The total amount owed is $22.75 plus 160 in court costs. So write this number down. You're 2,435.75.
Yes.
That needs to be paid. We'll enter a judgment by hearing today with a pay or vacate date of April 24th. 21st puts us on a Friday. I'm gonna give you until the 24th, 2023 to pay that amount. If that amount isn't paid by that date, a writ may issue. I cannot speak on behalf of your landlord. I can't speak on behalf of opposing counsel. I'm a neutral party, but I think reasonableness prevails, and that seems to be the case. So continue making this effort, and based on what you told the court, you should have this satisfied by the 24th. So good luck.
Objection.
And there's no objection to this judgment by hearing. The court, counsel, will you be submitting this?
Yes,
judgment?
I can submit a proposed judgment. Yes, Your Honor, with those terms.
All right. I know it's by hearing, but
Understood.
I appreciate it.
Of course.
Appreciate it. All right. All right, Ms. Williams, good luck.
Thank you, Your Honor.
You're welcome.
You
Keep those
have a
things
good day.
All right, you too. You have a better one. All right.
Bye-bye.
All right, it's Donald Gaddy here. Is Janice Brown here? Is Shantanique Thomas present? Is Norma Taylor? Is Mike McCool? Alexis Turner? actually have a dismissal for Alexis Turner. Is that accurate, Mr. Ingram?
I have a dismissal for Taylor and Brown, but I'm not seeing a Turner.
I have two that were sent, signed by Mr. Levine,
Okay,
Turner.
it might have
Says-
I might have just missed my list. So if we already sent something in, then that must be correct.
All right, so Taylor and Janice Brown. All right, let's do defaults first, because I can always dismiss the case.
Understood.
Calling case number strike that. Calling case number 2-334-3719 LT. This is Bill Properties versus Mike McCool and occupants at 3918 Nottingham Road in the city of Detroit.
Brent Ingram on behalf of the plaintiff.
Thank you. Does anyone reside at 3918 Nottingham Road? Counsel, you may proceed.
Thank you, Judge. We would move for a default judgment to enter. The rent to retain in this matter is $2,114. Court cost is $191.50 for a total redemptive amount of $191.50. Or I'm sorry, a total redemptive amount of $2,305.50. Writ to issue after 4/14/2023.
Court will enter this default judgment with the terms consistent with what was put on the record.
Thank you, Judge.
Default judgment is granted. Calling case number 2-334-3723, Bill Properties versus Priscilla Threat and occupants at 13909 Hartwell Street, apartment 2.
Brent Ingram on behalf of the plaintiff.
Thank you, Mr. Ingram. Is Priscilla Threat here? Does anyone reside at 13909 Hartwell in apartment 2? Counsel, you may proceed.
Thank you, Judge. We would move for a default judgment to issue. Currently, the rent to retain is $2,925. Court cost is $160.75 for a total redemptive amount of $3,085.75. Writ to issue after 4/14/2023.
Right, default judgment is granted. The move out date, payer move by April 14th, 2023, or writ may issue. And there was no appearance for the record for Ms. Lacy on the first hearing as well. Seems to be a trend.
That's correct, Your Honor.
You're stuck in here in the afternoon, huh? You have one case at 1:30. Calling case number 2-334-3715, Bill Properties LLC versus Shantanique Thomas and occupants at 13525 Santa Rosa Drive.
For the record, Brent Ingram on behalf of the plaintiff.
All right, and Ms. Thomas here. Is there anyone at 13525 Santa Rosa? And for the record, defendant failed to appear to the first hearing. Defendants failed to answer the call of the court for the second hearing. Counsel, are you requesting a default judgment?
That's correct, Your Honor. Currently, the rent to retain in this matter is $1,690. Court cost is $160.75. Total amount owing is $1,850.75. The writ would issue after 4/14/2023.
Default judgment is granted consistent with the terms read on the record. On the case number 2-334-3708, Bill Properties versus Donald Gaddy and occupants at 13909 Hartwell Street, apartment number 6.
For the record, Brent Ingram on behalf of the plaintiff.
Thank you. Is Donald Gaddy here? Does anyone reside on Hartwell in Unit 6, 13909 Hartwell, Unit 6. There's no response. For the record, defendant failed to appear at the first hearing as well. Counsel, are you requesting a default judgment?
That is correct, Your Honor. Currently, the rent to retain this matter is $1,205. Court cost is $160.75 for total redemptive amount of $1,365.75. Writ to issue after 4/14/2023.
Default judgment is granted consistent with the terms stated with the redemption amount of $1,365.75 to be paid on or before April 14th, 2023, or a writ may issue.
Thank you, Judge.
You're welcome. These last three cases are dismissals. I'll call all three of them together and just dismiss them at once.
Understood.
Calling case number 2334-3711. This is Bill Properties LLC versus Janice Brown, and occupants at 12724 Stouple Street. Next case is 2334-3716, which is Bill Properties versus Norma Taylor, and occupants at 12150 Stouple Street. And lastly, case number 2334-3722, Bill Properties LLC versus Alexis Turner, and occupants at 12771 Myers Road, Apartment 1. May I have appearances?
For the record, Brent Ingram on behalf of the plaintiff, and we would move to dismiss the three matters put on the record.
Dismissal granted without prejudice for cases ending in 711, 716, 722 as read on the record. Thank you, counsel.
Thank you, Judge. Enjoy your lunch.
Thanks. I'm fasting, but it's all right. I'll see you back at 1:30. I'll make use of this hour.
Sounds good.
All right. Take care. All right, court is adjourned until 1:30. I'll see you all back at 1:30. Feel free to hang out in the Zoom room if that's your desire.
may be entitled to compensation. Call 1-800-5 Based on the fact you requested BSEED, the government agency, to inspect your home on 2/17/23, I want you to know that retaliatorial eviction is a possible defense for termination of tenancy case under landlord's. Possession. No, I don't know. Retaliatory.
Good afternoon. Good afternoon, everyone.
Hello, Judge.
Good afternoon.
I see Ms. Shy, you're here for Beans, lonely case.
Yes, sir.
Right, let's see. All right, this afternoon, I'm not waiting an hour to call defaults. I'll wait 30 minutes just to, that's reasonable. It is the afternoon. Is Teresa Goodwin Martin here?
Yes, I'm here.
Okay. I'm gonna put you in a breakout. Do you want legal counsel, Ms. Martin?
I'm on my regular phone, so I called in.
All right. Would you like to speak to legal counsel?
Okay.
No, Ms. Martin, you have an option to talk to counsel, talk to the plaintiff's attorney, and talk to an attorney to help you talk to the plaintiff's attorney. So it's all the way,
Okay.
So do you prefer to talk to an attorney?
Yes, that will be fine.
Okay. Have someone from Lakeshore speak to Ms. Martin, and then we'll call this matter.
Yes, Judge. I'll place her in a breakout room. Miss Martin, you should get a prompt on your phone in just a second to go into a breakout room to speak privately with an attorney that can help you.
Okay, I'm on a regular phone line, so do I just hold?
I think it's gonna automatically shift you to breakout room if you're on the phone.
Okay.
All right. And Ms. Counsel will call it as soon as they come out.
Understood. Thank you, Your Honor.
Let's thank it. Welcome to 436.
Thank you.
All right, let's see who's on your case. Oh, where this is just loose. This was just loose, attached to the other dismissal.
Oh, okay.
So somebody win it in some case. Miss Bankhead, where's Miss Albu? I try to give her a call and see if I can get her in.
Okay.
So that you can get out. So sit tight. We only have 5 cases.
Okay, no problem.
Is Charmaine Driscoll here or Tyrone James?
Yes. Yes, I am. Latiria Driscoll.
Latiria Driscoll. Good afternoon.
And Corrine Ford on behalf of Tyrone James.
All right. So, Ms. Driscoll, are you phone number ending in 2825?
Yes, it is.
Okay. I'm just gonna put L Dris. Okay. Do you have legal counsel or legal representation?
I'm not sure if they hear Lakeside Shore, Sean Tate. I talked to him on the last hearing, and I'm not sure if they hear, but he did send me stuff for this hearing.
Okay, is he just, was it advice only?
Well, it was an email just stating my claim, you know, what I could use for defense.
Okay. All right.
Judge, I was able to find Mr. Tate's case with Lakeshore for Ms. Driscoll, and it does appear that it was advice only, and that's been closed.
Okay. Well, Ms. Driscoll, I'm gonna put you in a breakout room with Ms. Ford. And when you all come out, if you work a resolution, it's great. Go ahead, Ms. Ford.
Your Honor, is Mr. Wood here? Mr. Woods, Zachary Woods?
No, he isn't. He's my son. He really don't reside at this house.
I'm gonna put you all in a breakout room.
Thanks.
I will call this case. I'm gonna put you in room number 7.
Thank you.
You're welcome. Is Ethel Charleston here?
Yes, I'm here.
How you doing?
Hi, I'm fine, and you?
Fantastic. All right, Ms. Charleston, did you have the pleasure to talk to legal counsel or Mr. Horka?
Yes, I talked to legal counsel.
All right, and I see there's no appearance in the file. Was this on an advice-only capacity?
Yes, it was advice only.
Okay. I'm going to invite you to speak to Mr. Horka. And hopefully you all can work out a resolution. I'm going to put you in a breakout room, okay?
Okay.
So sit tight. I'm going to put you in room 11, Mr. Horka, room 11 as well. And I'll give you some privileges before you go. Ms. Bankhead, did you have an attorney?
No, I don't.
You want to speak to counsel?
No, I don't need to speak to counsel. I'm okay.
Is Michael Mulrooney here? All right. Well, we're waiting. I'm gonna call Attorney Apple and see if she plans on.
Okay.
Okay. Ms. Bankhead.
Yes, I'm here.
I have reason to believe, we were able to get in touch with Ms. Albu. I think she's gonna be zooming in. I'll have you all talk and hopefully you all come up with the resolution and then I'll call your case.
Okay, thank you.
You're welcome. All right, I'm gonna put you all in a breakout room.
Yes, Your Honor. Thank you.
Come on. People are becoming more and more literate with Zoom. I don't know, maybe we just, that's the right one some days. Mr. Harkin.
I think Ms. Charleston and I are ready on that matter, Your Honor.
Yes, I'm here.
Calling case number 2334378 Detroit 2L Plus Property Management versus Ethel Charleston and all occupants. May I have appearances?
Good afternoon, Joe Herka, P75969 on behalf of the plaintiff.
Thank you. And Ms. Charleston, can you state your name for the record?
Ethel Charleston.
Thank you, Ms. Charleston.
You're welcome.
Counsel, were parties able to work out some type of agreement?
I think so, Your Honor. The current total of rent that is owed is $5,026 plus $165 in court costs, total of $5,191. Ms. Charleston indicates she made a $2,000 payment yesterday, so there will be further orders indicating that that payment will be processed and credited when the plaintiff is able to do so. So that would leave her at $3,191. She is going to pay that amount on or before May 19th. We will also add in $800 for the May rent, and that May rent must be paid on or before May 31st.
How much is their May rent?
$800.
So are we setting a move out date for May 31st with 3191 plus 800?
May 19th is if she fails to make that first payment, then that could be the move out date. If she makes that payment, then she's got to make the second payment, or that could become the move out date.
All right, let's do, the $800 is confusing me right now. Is it owed already?
It is not. It would be due on May 1st.
Okay. So is there any objection to entering the judgment for $3,191 payable on May 19th? Or is that not what you're asking for?
I just typically only have authority for about 30 days, and we'd be going 45 for that. So I was trying to have the additional month due and owing as part of that extended time period.
All right, so what would be the total amount as your proposal? What's your proposal, Mr. Harker? I'm just unclear right now. So just lay it out for me and
So the total would be 5,991. I'm presuming 2,000 will come off of that any day now. So that would put her at 3,991. She's got to pay 3,191 of that by May 19th, and the remaining 800 by May 31st.
how is she obligated to pay that remaining 800? Right.
She wouldn't be obligated to unless the party is stipulated to such an arrangement.
Okay, and Ms. Charleston, are you agreeing to this arrangement?
Yes.
Okay, well, problem solved, Mr. Harker. All right, is this in the form of a condition of dismissal?
Can do it as a CD, Your Honor. Box 4B, I would just need Ms. Charleston's permission to sign her name to that document.
Yes.
Yes, as in Mr. Harker has consent to sign, Ms. Charleston?
Yes.
Okay, all right, the court is satisfied. Mr. Harker, draw it up and we'll sign it.
So, Ms. Charleston, what box 4B means is if you don't make either of those payments, Attorney Cox's office can submit a judgment and order of eviction that will reinstate this case and could have a court officer to your premises. But make sure you make both those payments or work out arrangements with the landlord.
Okay, I will. Thank you.
All right, Ms. Charleston, good luck. You are free to leave.
Thank you.
You're welcome. Have a great day.
You too. Bye.
All right, parties are ready on Bankhead.
Yes, Your Honor.
All right. Calling case number 2-3-3-4-3-7-7-1, reverse mortgage funding versus Monique Bankhead and all occupants.
Morella Albo, P67035 for the plaintiff.
Thank you.
And Your Honor, I discussed the matter with Ms. Bankhead. The defendant indicated she will be moving out by April the 15th. So we agreed that we can remove her name from the action, dismiss the named defendant, and enter a judgment as to all occupants with a vacate date of April the 17th. With your permission, we can do that by hearing, so we can dismiss Ms. Bankhead.
Okay, the court will grant permission upon request of plaintiff's counsel and its mutual consent, and parties appreciate the gesture, I'm sure. So we're doing a judgment by hearing as to all occupants with the pay or vacate date of. Now, is this a termination?
It's a termination, yes, no rent owed.
So there's no redemption amount, there's just a vacate date. Defendant must vacate, all occupants must vacate by April 17th, 2023. Is that
Yes,
correct? And Ms. Bankhead, is that the understanding of the agreement?
Yes, Your Honor.
All right, so you are dismissed as a named defendant. However, a writ may issue against all occupants who are occupying the property beyond April 17th.
Okay.
All right, I wish you luck, and thank you, Ms. Albu, for popping in and taking care of this.
Thank you, and thank you for calling us, Your Honor.
You are welcome.
Thank you.
You're welcome. Take care. All right. Martin. Okay, so we're making some progress. See, Miss Martin's in the room. Miss Shy. Next. Court will mute itself and wait until something is ready. Parties prepared on seven, six, seven.
Is that Martin, Your Honor?
Yes, it is.
Okay, if you could have your clerk bring Miss Martin out of the breakout room. She's on a phone, so she couldn't exit. But we do have an agreement.
One sec. All right. Calling case number 233436767. This is Bill Properties LLC versus Teresa Martin and occupants on break.
Good afternoon again, Your Honor. Jenny Scheid on behalf of the plaintiff P64886.
Thank you. And is Ms. Martin present?
Yes, I'm here.
Can you state your name for the record?
Yes, Teresa Godwin Martin.
Thank you, Ms. Martin. Ms. Scheid, you may proceed. You have an agreement?
Yes, we have entered into a consent judgment. Ms. Martin has rent to retain of $10,905, court costs of $160.75, bringing the total to $11,065.75. The agreement is for her to have until April 30th, 2023 to pay or vacate the property, with giving her until the 14th to appeal this decision. I did advise her of her rights under MCR 4.201I that she would have 3 days to request that this be rescinded or set aside for good cause. And at this time, we are requesting that this consent judgment be entered.
All right, the court will enter this consent judgment consistent with the terms just placed on the record. So, good luck, Ms. Martin, Ms. Goodwin Martin. Have until April 30th to pay $11,065.75.
Okay,
If I
thank
could
you.
have Ms. Martin's approval, consent to sign this on her behalf.
Yeah, is there a consent for counsel to sign your name?
Yes.
All right, well, good luck. Thank you all both. You all have a great day.
You too, bye.
Thank you. If Ms. Martin can provide me her email address, I can email this over to her to utilize for any type of assistance that she is going to be seeking.
Ms. Martin?
Yes.
I have no problem with you all doing it over. She's on the phone, so Ms. Martin, can you give Ms. Scheid your email address? You just yell it out if you want. Or I can put you in a breakout.
Whichever is easier,
Okay,
Your
it's
Honor.
fine.
You mind your email address? It's up to you, Ms.
No, I
Martin.
can give it to her.
Okay,
No, I can
go
give it
ahead.
to you. It's TGODWIN25 @
Okay, Ms. Martin, I'm going to email this over to you and you can utilize this in whatever way you need to try to get any type of assistance you're seeking. That will expedite,
Okay, thanks.
hopefully.
All right, thank you.
You all take care. Thank you.
Thank you.
You too, bye-bye.
You're welcome. And then there were two. Tyrone James. Morning, Mr. James. Good afternoon, Mr. James. Are you in the wrong Sabree courtroom? Mr. James, good morning, good afternoon, sorry. Good afternoon. Can you hear me? Let's see. Turning forward. Are we ready on your matter? Do I need to get her out of breakout room? Yes.
Yeah, I think she's still in there.
Okay. Ms. Driscoll,
Uh-huh.
are you ready?
Yes.
All right. Calling case number 233437775 LT. This is John James versus Lateria Driscoll and all occupants.
Good afternoon, Your Honor. Corrine Ford on behalf of the plaintiff.
Good afternoon. Lateria Driscoll, could you state your name for the record?
Lateria Charmaine Driscoll.
All right, thank you. And Mr. James, it looks like you're connected to audio right on time. Can you state your name for the record? Maybe it. I'm unable to hear you. However, you are represented by counsel and I will acknowledge you as being here. So in the event we need your testimony, we'll figure out how to get your audio work. But I think we can proceed as it is right now, unless that's necessary. You do have counsel, so I appreciate your presence, Mr. James. Ms. Ford.
Yes, Your Honor, this is a case for possession only. A notice to quit was issued. Ms. Driscoll still residing in the premises. We ask that a judgment of possession be issued with 10 days to move out.
All right, Ms. Driscoll.
Yes.
What's going on?
I filed a complaint because he's not fixing anything, and then the next thing I know, I get this eviction notice.
What would you file a complaint with?
The city of Detroit.
Okay. Was rent owed at the time the complaint was filed?
I'm gonna say no, because he never came and picked it up. He usually picks up my rent.
So it's either no or, I mean, are you saying
No,
no because it's a benefit or because it's no?
No, I didn't owe.
Okay, all right. So go ahead, counsel.
There are a couple of things. So Ms. Driscoll was kind enough to email me the notice that she's talking about, the violation notice from the city. And that was actually, it looks like there was an inspection done on February 17th. The notice to quit in this action was actually served upon her on the 15th of January, more than a month before that.
I never received.
And also, according to my client, she hasn't paid anything since November as far as rent goes.
Because he hasn't come to pick it up.
Before us is a complaint for recovery to possession of complaint to recover possession of property. There's no rent alleged as owing.
Correct.
This is a complaint looking for the notice. The notice says that Since he was terminated by notice of quit. Are you still residing in the property located at 12031 Fisker?
Yes.
All right. All right, do you have any other defenses, Count?
Other than I filed a complaint because he's not fixing anything, and I was waiting on him to come back to fix the bathtub. The next thing I know, I'm going through court. So that's my only defense. I filed, and now he's terminated. He's trying to get me put out.
All right, do you understand what's going on? Ms. Driscoll?
Yes, he wants possession of his property.
All right, and you haven't presented a defense that would preclude this court from granting a judgment for the possession of the property. Do you have anything else?
Well, just what Attorney Sean Tate sent me from Lakeshore for my defense.
I don't know what he sent you, and Mr. Tate didn't represent you either. So what would?
But then can I get an attorney to represent me? Because I don't really know what's going on.
You can get an attorney to represent you in the event that you want to appeal the judgment today, but you've had more than enough time to obtain counsel, and you also spoke to counsel in the previous.
Yes, and that's when he gave me the retaliatory eviction. Is my defense.
Well, in the event, I don't see anything that's retaliatory. The plaintiff's counsel has explained that the notice to quit was sent before you contacted the city of Detroit based on the date.
And again, Your Honor, I never received that. So I have no recollection of that. The first thing I got was on March the 19th, saying I had a court date on the 21st. That's the first time I knew I had a court date, and that's when I talked to Mr. Tate at that time. But up until March the 19th, no, I didn't know. I probably could have got counsel had I known in advance, but no, I didn't receive anything.
All right, no, I'm saying in advance to this hearing. Because you had counsel at the last hearing, and then in advance to this hearing, if you wanted counsel, they're available. And if Lakeshore wouldn't retain you, then that takes away maybe 33% of the potential free counsel, not to mention retained counsel, that's paid retained counsel. But court is going to enter a judgment by hearing. Ms. Ford?
Yes.
How much time are you willing to give? What time are you asking for? How much time are you asking?
And like I said, Your Honor, I mean, we're looking as quickly as you're willing to give. I mean, we'd request the statutory 10 days.
10 days would lead to April 14th, which would put you to April 17th anyway. So the court's gonna order a judgment by hearing with the vacate date of April 17th, 2023, or writ may issue.
All right, I will submit the judgment.
All right, that's the final judgment of the court. Ms. Driscoll, good luck.
Thank you, Your Honor. Have a good day.
You're welcome. Now your audio works.
Yeah, I see.
All right, I'm gonna remove you though. You're free to leave, Mr. James.
Okay, thank you.
Well, Michael Mulrooney here. Sit on this last case until Mr. Harper comes back. Don't want to get too far into the afternoon. Lecture legal.
Yes, Judge.
We're done.
Yeah, I wasn't sure if we were waiting for Horka, so I was gonna help you find him if we needed him, but
Hey, listen, I had a cover sheet for dig through the trash here. It was 43763, case number ending in 43763. And that case number was actually 93763. It was Attorney Norsegian's case, and it looks like it was adjudicated and a resolution was done at the first hearing. So
okay.
We're done.
All right. Well, and I think you didn't have anything set for Friday, if I'm remembering that email correctly. We're getting off easy.
So Wednesday is the last day of the week for us, which is a positive thing.
Yeah.
Then the 21st, I have nothing.
All right. So the
Should be
7th.
21st. If it is, let me know on the 14th. But I checked it. I think the 21st should be clear.
All right.
And yeah.
Well, then
Judge, we have a jury trial on April 26th. I don't know if you want cases on that date, or I can try to tell them not to put any.
On 26th? Yeah. Okay. Ms. Dias, 20. Thank you. Let's see. Yeah. All right. Thank you to everyone.
Yep. I think I'll see you tomorrow morning, but
all
have
right.
a good day.
All right. You all have a better one. Take care.